discharge
Yes.
the accused. That has been rejected under Annex 2 million. My sole contention before this on court, exactly in this instant case, the petitioner has no nexus to the allegation.
Where is the charge sheet?
Charge sheet I have not filed, my lord, but I just.
You want discharge without the court looking at the charge
My
sheet?
contention is the petitioner has no nexus to the allegation.
Maybe where is the charge sheet? Let me have the privilege of seeing the charge sheet at least. How can you be discharged by a court without even looking into the charge sheet?
So charge sheet I have not annexed, let the LCR be called for.
No, why should I call it? It is your petition, you have to substantiate the case. And these are minimum. In a discharge case, you say that you moved an application on 227. That is on the basis of what? Charge sheet only. Charge sheet is the basic document. So if you don't annex that.
My lord, that has been stated in the order.
No. Charge sheet, there are many other things maybe. Who knows?
My lord, just the background of the case, just I submitted, my lord. Actually, in this instant case, the Divisional Forest Officer Nabarangpur authorized to the concerned SEO to issue TT permit under Rule 4. So Rule 4, read with 7 and 8, clearly states that only the DOF is the competent authority. In case if he will authorize or instruct to a subordinate, he has power, he can exercise his power to issue TT permit. Here a case, my lord, joint verification already completed at the level of the Divisional Forest Officer. There is no role of the present petitioner. After order by the competent authority, being a subordinate, I have issued TT permit. Only this is only one question.
120B must be there.
Nothing is below. Nothing against me.
But 120B is there.
120B is there. So to that effect, can you lost?
If your superior has committed the offense, according to you,
shall be added as a prosecution witness instead of added.
That is their discretion. I can't
instead
advise
of
them.
added as a prosecution witness, he added as an accused here. And this is the cause of action.
That is the discretion of the investigating agency.
Submitting the background of the case. This is the cause of action arose since 2099 million. Case registered after 3 years. Absolutely no materials against me. To that effect, just I would like to take the indulgence of this honor court. Please have a glance for a moment. The authenticated order of the concerned DOF million. Once a DOF, I must assume.
Where is that? Those things are not there on record, sir.
No,
whether it is a part of charge sheet.
My lord, just a happy glass.
But kindly appreciate one thing. You have to show me the charge sheet, whether these are part of the charge sheet or not. I will have to see. You can't throw a document and on the basis of which I was a cognizance order. Place it on record. I have to see whether this document was part of the charge sheet or not. If it is not in part of charge sheet in cognizance stage, can I see the document? These are defense documents. These are very fundamental things.
Your lawsuit wanted to know how many prosecution witnesses are there.
So that you can get it from the charge sheet only.
Whether Amya Mishra is concerned to this case or not.
Oh, that was case. Oh, that was
that
yes,
case. Your lordship was. I think your lordship is not correct.
No, I will not hear it. I verified it. The same.
No, my lord.
No. Leave this matter before some other bench. Where
Amya Mishra, son of Bansanidhi Mishra.
I am not a part of subject to the permission of Honorable ACB. I will not hear. There is some problem. You and meanwhile file the charge sheet.
For instruction of my client.
No. I verified it.
My lord, Amya Mishra is not the accused in this instant case, but and no allegation in the affair.
But he is one of.
They have added as a accused.
So then anyway, why should unnecessarily create some problem?
So
let it go.
Before any other bench.
Any other bench where I am.
Obliged.
Item 2.
How many matters are there?
4 matters have been tagged.
Three matters.
Two of my brother and two are mine, my lord. Or two accused persons. One Ashok Kumar Mahapatra is appearing for my brother. And for Fakhruddin, I am two cases.
You are Ashok Kumar Mahapatra, Fakhruddin, you are appearing.
I am appearing for two cases.
Why two petitions?
My lord, two cases, my lord.
Two cases.
Two cases, my lord. Two cases instituted on the same day. Very peculiarity of the case is that, my lord, Your lordship will see,
Both the FR,
both
contents
FR
of a
contents
FR
of the
is
same and
same.
occurrence same day,
same
same time,
language, same wording, same time,
two places
two
the
for
occurrence.
two PSKs.
And word is also same. How can this be
In fact,
possible?
contents of the FR are same.
I'll read my
Yes,
letter.
Ragada sir.
They have filed anti-suitable application.
That is the
That
difference.
has, when they have not get any order
Out
from
of
that.
these two FIR, which is correct? You tell me.
Correct.
My lord,
I'm
Anticipatory is
reading-
rejected.
my lord.
Anticipatory bill is a different.
Basing on the statement, one sister
Let us
statement
see,
there,
let
my
us
lord.
see.
Yes.
One FIR first.
My lord.
Let us see one FIR.
May I place my
The item first item
my
FIR.
friends?
3497.
This is the 3-4.
PS case number, my lord.
176.
176. Read it.
Page number 10.
Okay, read it.
Operative person, page number 10.
I see Vishnu Charan.
Naik, son of Sudarshan Naik, so and so, my lord. So this Bhadrak, due this affair with content that today, that is 21/22 at 6 PM, while myself, Havildar B. Chandra Maji, so and so, my lord. In PS vehicle being driving by so and so, we are performing evening patrolling at Sabarang PS area, received reliable information that huge quantity of theft coal which has been procured from Dhamara Bhadraga DPCL railway line is being loaded in a 14-wheeler lorry truck at Baswa Poda in a lonely place. To verify the fact, myself with accompanied staff proceeded to the spot and on the way found two nearby villagers, namely Gobind Panigrai, so and so and so and so and so and so, my lord, who we are returning to their home after relieving themselves in a nearby fields. I gave my introduction to two villagers and sought their help. Proceed with us as independent witnesses in the raid. They agreed and together we left the PS vehicle and with lot of efforts, we are finally able to locate the spot where the coal was being loaded in a lorry truck. We kept the PS vehicle at a safe distance and proceeded to the spot by taking the paddy field. On arriving close to the place, we found a 14-wheeler lorry truck in dark being loaded with coal. There are around 30 to 40 laborers who are lifting the gunny bag loaded with coal from the dumping yard to the rear of the truck. We carefully listened what they were conversing among each other and we are able to hear one of the persons saying with laborers that Tiniju Mukye, Ashok Mahabatra, alias Mitu, Om Prakash Pati, Nilu alias Hrushikesh Das, Tapos, Pinturo Malochi, Emana Asuchanti, Pakho Heleni, Jaldi କାମ ସାର ପଇସା ନେଇ ଯିବ ଲୋକ ଦେଖିଦେବେ ନହେଲେ. At that point of time, we decided to raid the place and when we came out from the buses and shouted him loud voice introducing ourselves as local police. Then all of a sudden, all the people present
Okay, this I read. Next FIR.
Next
My client is concerned. Then all of a sudden, all the people present there began running here and there. While running, many of them saying, "Are police asira re, Hokka kuade golu." And neither the petitioner present, Hokka is the present petitioner. Hokka kuade golu, boncha, agre jaga chadi. Nohole police guli martho. This line is only added in the FIR, and this statement of the informant is also recorded in 161. He has not narrated, whispered any this line also. That how. So
We say them, but due to darkness, we could not.
nothing.
Okay, let us see the next
Yes.
FIR.
Next FIR, my lord, PS case number.
PS case number
5330.
530.
Yes.
Bail application number
It is a-
393495.
Yes.
It's a different police station.
Come to page 10 again.
Page 10, yes.
Yes.
I so and so, my lord.
Name changed. Okay.
Name change.
It is on 20th.
Same day.
Because of PS is different.
Different. One is
No.
Bhadrak,
That is
rural
Sabarang,
police
that is
station.
Date of incident
Same day.
Same day.
Same time,
Same
so-
day.
at 11 PM.
Again.
This was at
8 to 12. Time differs, my lord, 2 PS
no,
police
no,
station.
not same day. That was on 21
My lord.
10 to 2022.
And
This is on
two
20th.
Informant difference, my lord. And they are having 10 cases against them, my lord. They are doing this type of offences. At this stage, my lord, at this time of my lord, question, have the case.
Let us understand.
Sorry, I'm sorry.
Let us understand.
This
What
guy-
exactly? See,
he thought that the FIR will be registered, my lord.
listen, this FIR is regarding an incident on 20th October
My lord.
at 11 PM.
Yes.
The earlier which one you read it,
21st.
that is on 21st October at 6 p.m.
6 p.m.
These are the two different incidents.
But contents are same.
Line by line.
Content is same, sir.
Things, sir.
Similar sir offenses they are doing.
Everything, sir.
ନା ତାପରେ ସେଥିରେ ସେମ୍ ୱାର୍ଡ ୟୁଜ ସାର୍
Same
ଲାଷ୍ଟ
word.
ଲାଇନ ରେ ଭାଗରେ ଆରେ ପୋଲିସ ଆସିଲା ରେ ଫକ କୁଆଡେ ଗଲୁ ବଞ୍ଚା ବଞ୍ଚା କେନ
ତାଙ୍କ ସେମିତି ଗୋଟେ trick ସେଇ ଗୋଟେ trick ରେ କରୁଛନ୍ତି ଆଉ।
ଇଟ୍ସ ଭେରି ଗୁଡ୍ ୱାର୍ଡ ମାନେ ସେମ୍ ଇଣ୍ଟର ସେମ୍
And
ୱାର୍ଡ ସେମ୍ ଥିଙ୍ଗ
that
Same
out the
line, same line.
investigation going on, they are avoiding the police arrest. For that reason, file anticipated that has rejected, come to this one for casting a paper.
When will you complete the investigation?
I'll take instruction on that.
No, see,
They are absconder, my lord. How can the police?
listen.
Man, they are absconded.
Fire is in 22, October 22.
My lord, they are absconded, my lord. The
Since they
police
have not-
searching them,
Not got the bail, they will abscond only.
my lord. If police arrested them, then will be sound pilot, my lord.
kindly my submission before lordship mala this word this complainant here in this case mala the complainant is Sudhanshu Shekhar Jaina the running page 50 Sudhanshu
Ita alaga alaga.
statement
In front difference informant.
that because complainant saying that I heard that फक ए जो word so far the present petitioner is concerned कहला जे किछि लोक कहले जे अरे फक कुआडे गलु बंचा बंचा
See, that-
Hey, using say.
neither फक was present
One situation सेटा नाही किछि.
neither I am present nor mu चोरी रो अछि
Why don't you, if this is
Yeah.
the position, why don't you cooperate with investigation and
No,
finish?
I am ready, we are ready, my lord.
One-
Because of-
what is the substantive thing even accepting the entire affair then your lordship come to the running till 15 the complainant statement itself because your lordship my lord prosecution cannot override his own statement own prosecution case your lordship come to the running page 15 the statement of this complainant itself running page 15 the statement of Sudhanshu Shekhar my brief it is the brief of my I have annexed this statement 161 statement entire 161 statement I have annexed my lord running page 50 my lord in CRLMC number 3435 here 3435
3435, okay. Yes,
running page 50
yes.
lordship God this is the statement of the complainant who has lodged the affair and saying that mu sunili are कहउछंती किछि लोक फक पळा पळा
35, huh?
35 no, running page 15 1515 that is the statement of the complainant he is the sub inspector of the police that sir सब सेम मनारे किछि ने लास्ट आडको सर जो वाटर होइला हमें बाध्य होई अनति दूर रे गाड़ी रखितवा लास्ट 3-4 लाइन्स पूर्व रखी आसीबार आमे माने घटनास्थल को चढ़ाव करिया को जाई योजना करी आगे बारे सुनिबा पुनर्बार सुनिले ज कहले अरे पुलिस वाला आसिला रे बोलेरो छाडी जागा पळई चल नचेत पुलिस हमको गुली कर दे जदी से वर्ड ता एग्जैक्ट जदी कोटेड कले खाली फक वर्ड ता कले he has omitted the word फक मु कहिली बोले फक वर्ड को जो चिलेउथले मो ना भी नहीं स्टेटमेंट 161 statement this is the statement of the prosecution
Fak
it is
word.
complainant statement so matlab how
You are absolutely correct. I understood it. Because the FIR wordings and everything is same, exactly.
same
But the whole difficulty, it is at the investigation stage. There are two different incidents and you have not cooperated with the investigation.
I'm coming
And who knows that I'll record all these things. And why don't you cooperate and
Mallet police.
I will direct them to close the investigation as quick as possible.
Mallet, it's a false case now. Police will arrest me. I will remand it to custody, Mallet.
So those things,
That is the Mallet.
that is
It's
why
the malice.
don't
Everything is a limit.
convert 482 to
Everything is a-
430.
No, I'm not that is it's everything is the limit to the Mallet malicious prosecution. Your lordship knows, Mallet.
Right, but
So these types of even accepting, suppose if your lordship will accept my, I will accept.
which
the
FIR I'll pass?
Suppose-
Which
suppose-
FIR I'll pass? You tell me.
Suppose
Which one I'll pass?
Pardon?
Which FIR I will pass?
Both the cases, Mallet, in both the cases.
Both they can't. One is wrong, one is right.
Sir,
This is your case. Which one I'll pass? You tell me.
sir, your lordship mate mane
So that is the dilemma. That is the dilemma. There are two FIR. You say that both the FIRs can't be correct.
Both, sir.
Either of these correct or either have wrong.
Sir,
Both these things
sir,
are wrong.
I'm
Which one I'll pass?
adding.
You challenge both.
I'm adding to one sentence.
Yes.
In another case also,
Hmm.
the complainant is lodging the FIR and this is the substantive thing. This is the substantive thing. Evidence material is against me in the FIR. And your 161 statement, you yourself, you are also omitted my.
I'll call for the CD also. I'll
in
check both the
the-
cases.
I have annexed in the.
My lord,
FIR.
what
In the complainant statement.
My lord, owner of the
I have seen
See,
it.
no, I will take a case रे मध्य आरो केस रे मध्य से 161 स्टेटमेंट एफआईआर हेला तर 161 स्टेटमेंट मोन आटा नाही जमा से कंप्लेन मते जदी 161 रे नाही खाली एफआईआर खाली कंटेंट्स रे खाली गोटे लाइन लिखले जेटा को नीचे कंप्लेनेंट himself omitted in 161 statement. So how can
My lord, I am read out only 161 statement of one of the owner of the vehicle, my lord. ମୋ ନାଁ ମୀର ଇବ୍ରାହିମ ଅଲି। ମୁଁ ଆଜି 6/12/2026 ତାରିଖରେ ଆପଣଙ୍କ ପାଖରେ ଲିଖିତ କେସର ମୋର ଏଇ ମୌଖିକ ମାନ ଦେଉଛି ଯେ ମୋର ଗୋଟିଏ ଟ୍ରକ୍ ନମ୍ବର ସଚାଂଶ ଉକ୍ତ ଟ୍ରକ୍ ଚନ୍ଦନପୁରର ମଧୁବାର ହାଟ ଗାଁର ଫକିରୁଦ୍ଦିନ
But according to me,
that truck has been seized.
One of the FIR is a planted FIR.
Different time, my lord. Both the cases and
That is the
informative defense, my
that
lord.
is the advantage.
And for that is the 10 cases against them, my
In
lord.
two different places. What is the difference between two police stations?
One day after, my lord, it is 20th and that is 20th.
No, difference.
One district, one Bhadrak district within Bhadrak district, my lord.
No, distance. How much distance?
it's my lord, distance
Bhadrak one is Samrang PS, another is
Sabran,
Bhadrak. Bhadrak rural.
around 40 kilometer.
40 crore, hey,
20 kilometers.
kilometers.
Therefore, there are chances that if people are planted, this way.
अच्छा तापर आउ गोटे सर
Because exact words in FIR, exact words.
My lord.
Changing the name,
Might be-
time, and everything same.
Might be they are using that word as their code word, my lord.
maybe they are the accused.
Bhag.
Maybe they are known criminals.
Yes.
They may be.
Maybe.
They may be. I am not doubting that.
My lord.
Even if known criminal, can you fix them like this?
This is not the stage, my lord, to quash the affair, my lord.
That is there.
And they are absconded.
See
If-
the way these police is.
Police is my lord.
But they have to cooperate the investigation, my lord. If there is no such allegation, then they will
If they would have got the anticipatory bail, they would not have come to.
My lord.
If they have not got that is the reason they are here.
Your lordship know the
But
contents, guideline of the.
But what best could be done at this stage is, let us understand that there are two FIR.
Yes.
Now investigation has to, I have record everything.
Fine.
Investigation has to take complete. I can't intervene at this stage. And since you have not got anticipatory bail, I will make some observations so that you may get the bail also that way. Okay? And I'll call for CD. We have to find out which FIR is right, which is wrong.
Yes, sir.
That's the best thing we can.
Yes, lawful will be
Let us do within the parameters of law. And
No.
Mr. Ragada will also
No.
be agreeing to that.
Second, cost of repetition, I have submitted one thing. Everything has a limit to the mallet malicious procedure. I know police is planting some cases sometimes.
Don't make me further wiser to read further, and I'll dismiss it.
In my case, I have not applied anticipatory bail in one
Let
case.
let us do it.
Substantiveness कोन मते ना सजा है
There are-
ना कोन अछि से
There are
word रे
ସବୁ ଗୁଡାକ FIR common order କରି. The counsels for the petitioner in all the court cases submits as follows. Don't show appeals for some particular. There are two FIRs registered in this, registered allegedly pertaining to two different incidents. FIR number 176, what is that?
Sabran PS that is
No. FIR number, which is the earlier FIR? This is,
FIR is
yes, FIR number 530. 530 was registered, 530 of 2022 was registered in the Bhadrak Rural, PS Bhadrak Rural on 21/10/2022 at 8:25 hours pertaining to a alleged incident of 20th October 2022 at 11 p.m. Next. Another FIR being FIR number, where is that?
Sabran PS
1 minute, being FIR number
176
Oh,
Sabran PS 176.
1 minute. Have patience. Being FIR number 176, being
My lord, my mention the police station name.
1 minute, let me complete recording this. Another
FR number 126.
176 of 2022 was registered in Sarang PS,
Sabrang.
Sabrang PS at 23.30 hours on 21/10/2022, which appears to be pertaining to an incident of the same day at 6 p.m. Next one. Peruse both the FIR. Peruse the content of both the FIR. And I found that the contents of FIR are verbatim same, except the change of the name of the complainant, timing,
And the vehicle, my lord. Also.
and vehicle numbers.
Two vehicles, different two
Vehicle.
vehicles.
Numbers. However, the allegations made against the accused persons are exactly similar to the exactly same in both the FIRs. Both the FIRs. And counsel for the petitioners attempted to take me to the statement of the complainant recorded under 161 CRPC to substantiate the fact that the contents of the FIR are nothing but a planted story. Next paragraph. The investigation in both the cases are still going on. Also, the attempt by the accused persons to get pre-arrest, get the concession of pre-arrest bail has failed, and their has failed. As the coordinate bench of this court, this court has rejected their plea of anticipatory bail.
One case I have not applied for. In one case I have not applied. Also
One
for
case
the-
he applied, another case he has also applied.
Overall, okay. Even if you apply, you will get the same result. Plea of anticipatory. Also, the petitioners have now filed these criminal MCs, four criminal MCs, challenging the seeking quashing of the FIR. Next, I am afraid at this stage, giving indulgence to the petitioner may not be appropriate. Full stop. Appropriate under law. I have inquired the stage of trial, a stage of investigation from Mr. Ragada, who submits that since the petitioners are not cooperating with the investigation is still investigation is not progressing. Then counsel for the petitioners submits that they would be extending cooperation to the investigating agency so that the investigation of both the FIRs could be concluded to ascertain as to whether any of these FIRs has been falsely, any of the allegation in either of the FIR is falsely posted on them or not. Next one. Mr. Ragada further states that he will be placing before this court the entire CD of both the cases, copy of entire CD of both the cases, both the cases on the next date of hearing. Simply I am adjourning it for it is to come. Mr. Gada, when can you expect conclude it?
My lord, will take instruction and taken up on
13th of February.
my lord.
13th February. 13th February. आपको देखिए चेष्टा करूँ.
Then we'll cooperate, man. We'll go to the person, will be arrested unless your officer will protect.
Protect us.
No,
No,
otherwise, question of cooperating.
No protection. Once that I am very sure about.
Yes.
In 482, don't.
No, Your
No, you have got. If you have not applied for anticipatory bail, I can
That is
think
correct,
of.
but.
I can't sit over the appeal over a coordinate bench order rejecting your bail in a 482.
Bill is altogether.
This much observation I have given, I think you will get the appropriate relief from appropriate court.
From. See
In
that,
the
event,
we have no other appropriate. court, my lord.
They will appear, my lord, they will be.
They will, take- will,
Take into
well,
account.
certainly we, my lord, we
No,
can-
if you would not have gone to the 438 court, perhaps I would have. I would have taken a little different view. Since your coordinate bench has rejected your application, if I protect you, then I am superseding that order. That is
Your
not
lordship is
permissible.
not directing that to be released. Your lordship only directing on, because your lordship is.
Then
giving
438 is not available, but I'll exercise 439 in a 482.
Cooperate, so cooperate, then
Then
your
no
lordship will protect us. Only your lordship can say that till the cooper.
No, no.
Cities.
Please,
Protect, my lord.
please.
Then we may
I will go
protected.
overboard by doing all these things. Please. Next. I will quash it. Definitely. If I'll find anything, I'll definitely quash.
It's very well completely covered by Vajan Lal case. All the criteria.
Vajan Lal not at the stage of FIR.
FIR also can be quashed when your lordship in prima facie established.
Which
that there's a
one?
matter.
Which FIR? That's what I'm asking. Which FIR is wrong? You tell me, I'll quash it.
No, but your lordship is correct, but my contents of the my case.
There are two FIR.
Sir.
You say that both the FIRs are same. Content same, everything same. Which one I'll quash? Unless the police tell me that this is wrong or that is wrong. That's the whole difficulty. You got trapped in your own.
So court of all such is a court.
पहले quash कर दो. What are you talking of anticipatory bill? We will quash it.
Item 3, my lord, I pray for time, my lord.
Adjourn.
Item 4.
May I please, Your Lordship?
Yes.
Appearing for the
My lord, the
petition-
free copy of the order may be given in, I don't know, too much. Free copy of the order.
Okay.
in this case, Your Lordship.
You
has-
give instruction to the police.
My lord.
Just see, it's better to prosecute them in one case instead of doing two and losing both. After over enthusiastically, they have registered two cases.
My lord.
One may be wrong. Yes.
I am appearing for the petitioner, my lord. Your Lordship has called for the case diary in last occasion.
Did I call? Case diary be called in the meantime. You got the case diary? Yes, yes.
My lord.
What do you want? Yes, yes, no. What was this case?
Case arrest.
What was this case?
No, but here, there is a dispute, your lordship will see. Originally, when one CC case was filed, page 11, by the landlord, wife, husband of the land. The entire transaction is with the wife.
You are the tenant.
I am the builder. Regarding the apportionment of shares in construction of the building. There was allegation, your lordship will kindly see at page 12.
Case 12, huh?
Yes.
Yes. Yes.
Paragraph 3. Roman 3. So there was an agreement to construct certain portion and some money transactions were made.
For that, 138 is pending against. The check bounce 138 is pending. Now the final report has come wherein Arms Act and 307 has been deleted in the case diary. Due to 138, 420 is not being deleted. Question is, my lord, this is a dispute regarding the apportionment of shares in giving the building here. What I was praying, my lord, both the parties are now working in tandem. Their construction is going on. I am working, but the FIR is there. So if it is referred to mediation center at Bhubaneswar,
What
I think it can
what
be
do you say?
settled.
Yes.
Will you fight it out? And so you are businessman, why do you fight?
That is
Take it up.
the right way, my lord.
That's the right way.
My lord, let it be transferred to the mediation center at your lordship. May keep this matter pending.
Bhubaneswar,
Bhubaneswar.
High Court.
High Court le better
High Court रहेंगे ସେମାନେ କାହିଁ ଆସିବେ ଦି ଜଣ
So
ଭୁବନେଶ୍ୱର and they are
State
aged
better.
person. So ଭୁବନେଶ୍ୱର ହେଲେ ଦି ଜଣକୁ ସୁବିଧା ହବ ଭୁବନେଶ୍ୱର mediation center ରେ ଦେଲେ it can be discussed.
Yes.
I'll just record your statement and send.
Yes, your lordship may record my statement.
Mr. Bose appearing for the petitioner and Mr. ଆପଣ ନାଁଟା ପୁରା ଭୁଲି ଯାଉଛି
Pulokesh Mohanty.
Pulokesh Mohanty appearing for the Pulokesh Mohanty appearing for the opposite party number 2 submits that this is a dispute arising out of a collaboration agreement between them. One of them is the owner and the other is the developer. There are cross cases filed against each other. And however, in the meantime, they are developing the subject property in tandem. Therefore, they submits that they would make all endeavor to settle their dispute and request to send it to the mediation set. Since the parties are senior citizens, both of you.
They are senior citizens.
Since one of the informant, since the informant is a aged person, they have agreed to mediate they have agreed to subject themselves to the mediation center at Bhubaneswar district court. Accordingly, the matter is referred to the district
mediation legal services center.
District mediation legal services. That's correct expression.
Yes.
DLSA, Bhubaneswar. They may appear on, you will give it a.
My lord, your lordship will send it to the coordinator. Coordinator, after issuing notice, then we can appear.
The DLSA so-and-so.
DLSA Khurda at Bhubaneswar.
Khurda at Bhubaneswar shall do good to see that the mediation is effectively taken place. Awaiting the mediation report, the matter is adjourned to 29th of February.
My lord, one thing I request your lordship to mention. Your lordship may say that the convener or the secretary of the DLSA Khurda at Bhubaneswar will issue notice to all the parties.
Obviously, he will do it.
After they receive the order,
That is the procedure after that mediation.
They will follow.
That's the procedure.
Yes.
They will do.
Urgent to
29th.
29th January.
Complainant is now.
February. इतने दिन जल्दी थोड़ी होगा.
Time रखा.
Complainant is now will, if any son is appear.
Anybody.
You may adjust that. They will do it.
My lord, the most interesting, we are lawyers fighting here. They both are now in tandem, they are working.
Why do you
No.
fight then?
My lord, we have to do our duty. We have been.
Don't
we
fight.
have been-
Have coffee together.
No, we
I am agreed with
fighting
my
for
brother.
case, not for personally.
Not fighting, agreed with my brother.
Now, that should be the spirit.
Yes.
You know, if the matter is
If
to be
settled,
settled, it should be.
I think it can be settled because now in the meantime, Arms Act and 307 has been deleted. Only due to 138,
Do it.
420 is not being deleted. Other offenses are minor
See,
offenses.
420 will also go, 138 also will
All
go,
go.
if you settle.
Yes.
Both the things will. Very good.
obliged.
Item 5.
Item 5, my lord. In this case, Mr. Ponda, Devashish Ponda has been engaged, my lord. And the matter has been mentioning for listing without informing us. I may pray for any other day, my lord.
This is what is happening. Somebody mentions and how will I believe?
No, we have not mentioned, my lord.
So anybody but your friend has mentioned.
No, how it being mentioned, my lord?
Mentions, memos are given. We have to believe the memo or you have to inquire about every memo. Adjourn it to March end. March end. And note it down, don't entertain subsequently. March end, adjourn. Next.
Item 6.
Interim order will continue then, my lord.
Whatever is there, it will be. What is this?
Password, my lord.
Then we will start disbelieving the lawyers then.
This one.
Yes, password?
6.
Password.
Item 6.
Item
Yes.
7.
This case arises out of a matrimonial dispute.
Yes.
Both husband and the wife, they have settled their matter amicably and accordingly mutual divorce has been passed.
Very see. When can you bring her?
Madam?
When can you bring her?
Owner के बारे में आप डिविजन रखें ना joint application
30th, 31, first week of February, anytime?
Has to be approved.
2nd February. Deadline counsel for the petitioner.
Husband is in petition.
Uh,
I have
pet-
made her a patio.
Yes, petitioner submits that this matter is arising out of a matrimonial discord, and he seeks indulgence of this court to wash the FIR in subject
So the entire process.
and subsequent proceeding arising thereof. He has settled the dispute with opposite party number 2. Issue notice to opposite party number 2,
1, my lord.
One.
State is operative 2.
opposite party number 1, opposite party number 1. On the next step, the parties may present in the court on the next date of hearing. Next date of hearing.
9th February.
Huh?
No, February.
9th February. 9th February.
May I tell lordship, I is there to take.
Counsel for the petitioner further submits that pursuant to the settlement, the parties have also acted upon the terms of the settlement and applied for resolution of marriage on mutual consent, which has already been granted by the court of
Mutual divorce passed, madam.
which court?
Current judge family court Bhubaneswar.
Land Judge Family Court Bhubaneswar. In view of the aforesaid facts and circumstances, the further proceeding in CT case number 163 of 2016 pending in the court of SDJM Bhubaneswar is stayed till further orders. Yes.
Item 8.
Item 8 and next.
Item 8 can take no next week.
Adjourn.
Item 9.
Okay. Taken up next week.
Adjourn.
Item 11. Item 11.
Withdraw. Take the memo and withdraw. 12.
My lord, item 10, my lord, the no, 10 ଟା ସେ memo ଦେବେ ବୋଲି କହୁଥିଲେ ତ
11 withdraw.
11.
11. Item 12.
11. 12.
May I please? In this case, a case of FIR registered under section 341, 294, 323, 324, 506, 34 IPC. And the petitioner approached the report and was granted anticipatory. Madam, we have a glance to page 6, madam.
Is 6, huh?
Right.
Yes. Okay.
2 persons, Fakira Behera and Surya Kanta Behera.
Okay.
They are allowed to be released on bail.
Hmm.
Now, let's see page 7, the operative part of the order.
Hmm.
In connection with such and such case, be released on bail, furnishing bond of 10,000 with such and such.
Okay.
And thereafter, my lord, 307, my lord, may turn to page 8. Order of cognizance.
Yes.
307 has been added. So I have a limited way, the Honorable Court kind enough to direct that the petition on surrendering religion bail in view of their earlier religion bail, that will meet the purpose.
No, that Susila Agarwal says that that
438 is maintainable. And if a subsequent higher offence is added, then he is to approach before the forum by utilizing the section 438 of CRPC. And if that is rejected, then he is to appear before the concerned court. That is the decision of Susila Agarwal.
No, if the ratio decided because purely because the higher offence has been added, so it cannot be bail which has been granted earlier will not be cancelled. There is a ratio.
No.
There it has been held that you can again approve the court 438 that proof is there. But here I have,
Exactly.
just a minute, my friend. Here I have approached the Honorable Court on challenging order of cognizance because 307 adding of 307. If the Honorable Court also because while sitting on this alert 482, Madam can also try.
cognizance order cannot be passed.
No, I have not seen the cognizance person.
Ah.
But may say in view of the fact that he was on bail, let him surrender.
No, in a 482, why should I do? Either I'll see whether cognizance is order right or wrong. That's the only jurisdiction I have. And I will record your statement, you to take avail the remedy. 482s are not indirectly.
With all respect, but again, it's multiplicity application.
Maybe, but see, you question the cognizance order. I have to see whether cognizance order is tenable under law or not.
Yes.
If it is tenable, it's tenable. If it's
No,
not,
there
then
is-
I'll quash it.
Madam, my friend also agree with me that this Honorable Court also in many of the cases has directed.
I'll just record
consideration.
Susila, you give Susila
My lord,
judgment.
yes.
Take it.
This finding, very finding I have marked.
No, you give the citation. Mr. Khan submits that by order dated 16/2/2022, passed by the coordinate bench in ABAPL number 1133 of 2022. The coordinate bench has been pleased to grant anticipatory bail to the petitioner. Full stop. Subsequently, the charge sheet was filed in this case. Charge sheet has been filed in this case. Charge sheet copy, file.
Cognizance, Madam, say cognizance has been taken.
Charge sheet, when
Yes.
charge sheet was filed.
Charge sheet is all. Madam, may see page 8, CS number 44 dated 9/4/2022.
Charge sheet has been filed on 9/4/2022, adding a aggravated offence of 307 IPC. Full stop. In persons, full stop. On 17/5/2022, the learned court of JMFC Khurda has been pleased to take cognizance of the offence against the petitioners. Full stop. In the present petition, the said cognizance order has been challenged. The Mr. Chand submits that the bail, the anticipatory bail granted to his clients by the coordinate bench should be extended even after addition of the charge under section 307 IPC. He is praying accordingly. Accordingly, I am of the considered view that he has appropriate remedy under law, a remedy under law.
So, file back for
Law as he can derive the benefit of the judgment of the constitutional bench of the Supreme Court passed in 2025 SCC page 1 Susila Agarwal versus state. Full stop. At the stage, Mr. Chand seeks to withdraw this petition to avail the remedy under law by relying upon the judgment of Susila Agarwal Supra.
Yes.
You so Susila Agarwal I have mentioned.
No, but
You get it, no problem now. No problem. Now it is balancing act.
13 and 14 I prefer next year because I have to got this on judgment.
13, 14.
Hon'Ble.
15.
But in this case, local police was directed to.
Dispose of with aforementioned observation.
My lord,
In terms of observation.
my lord, with regard to compromise arrived between parties, local police was directed to
Yes, yes.
forward.
Yes.
Ma'am. Go ahead.
Both parties after settlement, they had furnished the joint affidavit before the police case.
Party.
What is?
Number 2 have appeared before the court through virtual mode. Hon'Ble Puma is appearing through virtual mode from Sundargarh. Having direct to the parties. May present with the 20 card and 4 along with the card and diagonal how to collect in the joint affidavit. Yes. Very
Yes,
well.
yes, yes.
Done?
Yes,
No problem?
no problem. Entire document has been sent by the investigating officer.
You place it and what is joint affidavit and everything?
Joint affidavit is there also. With the lordship's order and the joint affidavit, everything is there.
Very good. Joint.
Aadhaar card, photo identification, everything is there.
Okay, very good. Right on. This matter was taken up
Compromise.
by this court on 8/1/2024 and following order was passed. Para 2 to Niki, Pura Para 4th. Persons to the aforementioned order, Mr. Maharaj, Maharaj got the instruction from the IIC, from the IIC Talsara PS. He is placing on record the entire placing on record a joint affidavit filed by the parties along with the identity and along with the Aadhaar card, self-attested Aadhaar card of all the parties. Good, sir. Mr. Maharaj further submits that the parties had appeared before the IIC Talsara and place all these documents before him. He has now informed Mr. Maharaj regarding the fact that the parties have entered into the settlement. The instruction along with the documents are taken on record.
Yes.
Taken on record. Next paragraph. Having taken into consideration the fact and circumstance of the case. The GR case number 18 of 176 dated so and so and consequential proceeding thereafter are quashed. Petition is discharged.
Item 16.
May I please, Lordship? Lordship, this case is quashing of criminal proceeding on the ground of compromise.
Yes. What is the offense?
The offense under section 294, 506, subsection 2, 420 and 406 of IPC.
294.
50.
What is the allegation against you?
The allegation is that the petitioner was engaged the opposite party number 2. The opposite number 2 is a painter. And when he did not get the money under the for his work, he complained the complaint case before the STJ Mathagada, for which cognizance taken, and
now you have paid.
Lordship, we are ready to pay, and if Lordship be permit, then we file a joint affidavit in that light in next week any day.
You have implemented him also. Yes.
Lordship.
The petitioner has filed the present petition seeking quashing of the cognizance order dated 28/12/2012 passed by cognizance order is 2012. What happened to the trial?
NBW issue against the accused.
Oh, that is why you settle. Otherwise, you would not have settled. That is so and so, NCT case number so and so, so and so, so and so. Under section so. He submits that the parties have now settled the dispute amicably outside court, out of court, out of court. Next, issue notice to opposite party number 2, returnable within 1 week. The parties to file joint affidavit, and place on record that and appear before this court on the next date of hearing. 7th February. Bring them and finish it. Okay.
Lordship, interim application is there.
Huh?
IA is there.
In view of the fact that the parties have settled their dispute, 2012, nothing has happened. Now what will happen? Within 5 days, you issue notice on the application for interim direction. Nothing will happen. Bring them and finish. Yes.
17.
In this application, the petitioner pays for quashing of criminal proceeding matter on the ground of compromise matter. Parties have settled their dispute matter.
What is the offense? What is the offense?
341, 294, 326, 325, 307, 506 by 34.
307. You tell me. Yeah. Injury report. Injury report 307.
My lord.
What is the injury report?
Injury matter grievous.
Reason?
Parties have settled.
Party may
dispute
settle.
between my lord.
After killing
That's-
someone also you can settle.
No, dashing up a vehicle, my lord.
Whatever. What is the offense of weapon? What have you used?
Used, my lord, Fenga. Solded by
Huh?
Fenga.
Huh?
Fenga, my lord. Stick, my lord. Bamboo stick.
Stick.
My lord.
And you blow where? Head.
Head injury, my lord. Okay. Head, my lord.
Injury report ଆପଣ ପାଖରେ ଅଛି କଣ?
Nahi.
You have not filed anything. FIR. What is the investigation stage?
Notice just when asandu, in the meantime, I will take instruction.
Simply issue notice. You file at least. What is the stage? You are on bail.
No, my lord. Charge sheet has not been filed, my lord.
Are you in bail?
Investigation is going on, my lord.
Investigation is.
You are not on bail.
No, my lord.
So issue notice simply. 19th February.
My lord.
Item 18.
The FIR was registered when the present petitioners were student in MS Law College. Offense charge sheeted were under 13, 148, 157, 294, 427, 320.
Writing.
Yes, they were college election dispute. Now both of them have become lawyers and under me. Well, I'm seeking quashment on the ground of compromise. The informant is appearing.
Yeah, are you saying that it is an aggravated offense because they join your office?
No. After joining the office, they have become very good.
Both the complainant as well as both the accused only.
Complainant is.
What about the complaint?
Complaint is the principal. Principal.
To attack principal, then why should you get sympathy? Have you implemented
Complainant is the principal.
the petitioner, Mr. Bose submits the.
I think I'm appealing for the informant matter, for the complaint. We're also matter is amicable settlement.
That we will do it.
Yes, ma'am.
Lawyers for you.
2 of the accused are before them.
And what about how many accused are there?
One of them 7, 5 to 7.
Atal,
2 are before lordship who are ultimately became lawyers and they said that the Democrats should go away.
the others, what will happen to the others? If they will not compromise with the others, then.
It
It's true, it can be quashed.
No, it can be quashed, but why instead of doing a selective thing,
Selective changes.
why don't you?
They cannot, I have no contact with them. These 2 are now associated with me, so I can say about.
What is your instruction? Will you?
Other person are not coming to us, my lord.
Huh?
Other accused person are not coming to us. These 2 persons are coming to us and they are amicable settled to us, my lord. These 2 persons are coming to us.
What about the
You are not
investigation and all?
Others, they are not-
If others are there coming, they're not.
They're out of Odisha and they're residing somewhere, I don't know.
Charge sheet has not been filed. Where is the charge sheet?
Charge sheet page 13.
Who are they? These, where are they? These, your petitioners?
They have not come to me. The lordship says I can bring them.
Bring them at 2 o'clock.
2 o'clock, one can come at 2 o'clock. Mr. South can come at 2 o'clock. The other person is not there in town.
I would date fix it.
Because they have.
No, but still see, the complainant is a professor. Let us understand,
The complainant has filed a affidavit.
I also provided
Where
this
is
joint
it?
affidavit.
Joint affidavit.
My Bakalat number,
Mr. Pani is appearing for the complaint.
Date fix हो से आसं तो
1 minute. This is 17, na?
18, item 18.
I'm of the view, my lord, your lordship may at least ascertain the in presence of the informant, in what extent he has compromised this matter.
See, this affidavit, what is this affidavit? This Sushant, you have written, where is Sushant?
Sukant Kumar Nanda is the complainant. That time he was the hostel in charge, my lord.
Hostel in charge. There
That
was
time.
dispute in the hostel.
No, that's right. But what is this affidavit?
Affidavit, joint affidavit that he doesn't want to, your lordship,
What he-
parties have compromised the dispute and opposite party number 2 has not to decide not to proceed with the case.
No, he has given me some affidavit, this affidavit.
Yes. First page, your lordship, thanks.
No, this affidavit, see, at least a standard affidavit has to be filed. What is this affidavit? I have not seen this kind of affidavit in my
And
life.
मत्ते वोटे copy दियो देखो.
And see, second page. What are you doing? Just see the second page. The facts stated above are true to the best of my knowledge. Which state fact? No, this is no way of.
This is not the.
We have
one way
entered
of
into a
affidavit.
settlement on sunset day. Some facts are has to be given.
କିଛି ତ ନାହିଁ ଏଥିରେ.
Parties, କୋଉ case ରେ କଣ କିଛି ନାହିଁ.
କିଛି ନାହିଁ.
I can utilize this affidavit in some other affidavit, some other case also, where between parties. Which case, which FIR, what is this?
3 line ର affidavit.
In the High Court. You don't do like that. File a better affidavit.
Yes.
Which affidavit, which case you want to settle, why it was registered? You have to improve the standard of drafting at least little bit. I'm adjourning it to 29. You come with the proper affidavit, then
Your
we.
lordship may indicate the name of the opposite party so that we can file a better affidavit in the
And
meantime.
the name of the council for the party may reflect in the cause list.
We'll file a better affidavit so that.
Better affidavit giving particulars which
My lord,
FIR,
my lord.
what happened, what is something.
Yes, my lord. Sorry.
Yes, sir. My lord, your lordship.
I'll
Then
answer.
the front page I'll take and use in all the FIR.
No.
No.
He should write the case number.
Case number कुछ तो लिखो भाई. Settle in which case you have settled?
Yes, my lord, your lordship is absolutely correct. That is not in it.
Then that first page I'll take a photocopy and in all quashing petition I'll affix it and.
No,
quash it.
No. A better.
In details, that's the thing. Wakalatnama is taken on record, name will be reflecting and 29th they'll come with a better affidavit.
My lord.
ठीक है?
Mas-
Okay.
May I please, your lordship? Your lordship, an application under section 482 of CRPC.
Yes.
My humble prayer before this honorable court, the passing the NBW on order dated 2/1/2024 that by the London JMFC.
NBW, against NBW.
Yeah, lordship, yes, sir.
Bail, when you got the bail?
Your lordship, pass an order on honorable court, 19/2023, I am on bail 1/11/2023.
नहीं, bail order. When you got the bail?
मत से देना लगे.
Are you on bail or not?
Yes.
When you got it?
1/11/2023.
Huh?
1/11/2023.
1/11/2023. NBW which order? Yes, sir.
Your Lordship, Annex 3.
देखो,
This is the condition of the honorable court.
I know.
Court's order has not
He is not-
complied. And
The-
that is why bonnet has been issued.
You will have to comply now
Yes.
Your Lordship,
and pay little cost here.
Yes.
yes.
How much cost?
Your Lordship, that 50% amount of 2 lakhs rupees.
Although he give you 1,000 here, then you go and comply.
हाँ.
That लिखो. The
ताकि 50% दवा पे डायरेक्शन दियो तो 50% कंप्लाई करो प्लस 1000
that's the interest part. देखो, the petitioner has challenged the petitioner has assailed the order dated. Which order dated? Order dated?
2/1/2024.
Huh?
2/1/2024.
2/1/2024. Passed by JMFC 1 Bhubaneswar in city case number 425 of 2023, whereby the land court below has issued NBW against the petitioner. How many petitioners are there?
Oh, you say one petition.
One.
Petitioner for having failed.
JMFC 1,
What?
you also may indicate JMFC 1.
JMC 1.
1.
For having failed to comply the condition of the bail. Condition of bail granted by which court has granted the bail?
Your Lordship,
Our High
Same
Court.
court.
Hon'Ble High Court.
Honorable High
Condition of the bail, bail, full stop. On 1/11/2023, the coordinate bench of this court enlarged the petitioner on bail with the certain condition.
1910,
हाँ.
1910, 2020.
19/10/2023.
1910
2023.
23.
Vide BLAPL number
9887 by
while
2020.
BLFN number 977.
887 by 2023.
ठीक है.
Yes.
Next problem. The petitioner undertakes to comply the conditions imposed by the court granting him bail and appear before the court below.
Yes.
Court below as and when directed and also cooperate with the and also as and when directed, next paragraph. The order dated 2/1/2024 passed by JMFC 1 Bhubaneswar in city case also is set aside to the extent of issuing NBW
Yes.
against the petitioner, subject to the petitioner depositing ₹1,000 with the High Court Welfare Association. Deposit
ଗୋଟେ ଟାଇମ୍ ଟା ଦେଇଥାନ୍ତେ
Lordship, give some.
within
ସେ ଯୋଉ 2 months ରେ comply କରିବା ପାଇଁ ଆଗରୁ order ହେଇଥିଲା
ସେଟା ଟିକେ extra.
after being released on bail within 2 months.
ऊपर कर लिख लो, क्या ऊपर पैराग्राफ था ना तार इमीडिएट ऊपर था जो लास्ट पे कर हां
The order to 2/1/2024 part by the JMFC 1
क्या ऊपर था
the petitioner undertake to comply with the conditions proposed by the
condition imposed by the court granting bail within a period of
3 months, Lordship.
not 3 months. You have to go to that court. 2 months he is given. I will extend it.
Sir,
That
two-
court is, you have to go to that court.
Lordship, 2
then.
months.
2 months ଟା ହେଇଛି ନା 2
Two
months ଟା ହିଁ
months.
ରହିବ
2 months नहीं कर
Yeah,
I
Lordship.
can't change.
Yeah, Lordship.
But leave it like that. Whatever conditions are there, you will do it.
yes
I can't change because that court order, how can I modify?
ଆମ ହାଇକୋର୍ଟ ଅର୍ଡର ଦେଇଛନ୍ତି ଯେ 2 ମାସ ଭିତରେ after being
ସେଇ କଥା
released
ନା
to
ଯଦି
pay
modification ଦରକାର ସେଇ କୋର୍ଟକୁ
ସେ
ଯିବାକୁ
କୋର୍ଟ
ନା
ତମେ ଯିବ
ମୁଁ ତ କରିପାରିବିନି 482 ରେ ହଁ ସେଇଠି ଛାଡି ଦିଅ
ଆପଣ 2 ମାସ
comply
comply କରିବ ଆଉ
comply चलो ठीक है हो गया जाओ dispose
item 20
1,000 rupees you deposit the NBW is cancelled
Yeah, Lordship.
then you do whatever you
yes
item 20
Yeah, Lordship. Item 20. That's a similar matter.
same matter
Same
only
matter, same
PS case different
same
And
order,
PS and city case.
same order देखी करियो हाँ चलो ठीक हाँ 20 ना 25
20
25 हाँ
21
See, another expedition trial maybe.
NBW cancel, you are coming for a NBW cancel, you don't cooperate the trial court, you want now expedition.
21.
My lord, may I please pay? My lord, this item to withdrawal.
Withdraw.
Permitted.
Okay, withdraw.
With the
Memo
report,
Memo,
I will file my.
you get the memo, and give it, then subject to giving. You give
With
it
the
right
liberty,
now, we'll do.
with the liberty to file.
No liberties, you have all the liberties.
Ah.
Liberties are always there.
22.
Memo नहीं किने वहाँ दीटा matter अच्छी है.
Memo दे दे.
22
22.
pass over.
23.
Right, please, your lordship. I'm appearing for the petitioner, your lordship. On the last occasion, your lordship was pleased to issue notice. We have received instruction from the OP2 that if the family someone has died, so that's why he is not able to be before your lordship.
Yeah,
So-
put it in the first week. Settlement, matter
Yes,
settlement,
Lord.
first week, 6, 7, 8, 9, any
Nine,
days.
nine.
9th,
Interim order passed.
entry mode, 9, yes.
Obviously.
20,
24.
yes. Pass over, okay.
25.
25. Pass over. I'll just come within 2 minutes. Yes.
26,
Pass.
27,
May, lordship. This matter has been amicably settled.
Informal lordship, I have given the Bhoklatma along with the affidavit.
What is the offense?
Lordship, charge sheet has been filed offense under section 341, 294, 323, 308 of Indian Penal Code.
Huh?
308 of Indian.
307 is not there?
No.
Yes, Mr. Ragada, you tell me.
My lord, I already obtained the case diary, my lord.
Hmm.
And 307 earlier there, and that has been deleted, and 341, 294, 323, 308, my lord. And
Lordship, informant is the stepmother of the petitioner.
Stepmother of the petition. What is the allegation? What is the allegation? You have attacked
Lordship,
Vasanti Munda.
after death of the first mother, the father again married to the informant.
And the son had
Due
a
to some
loggerhead with
My lord, what is regarding with them? That is their allegation, my lord. And in fact,
has he attacked this boy? Is attacked. Attacked physically to the stepmother.
No,
That may be the
case is not with me, my lord, but in fact, my lord, there are affair.
Have you filed joint affidavit and all?
No.
Then where are they?
Informant.
Huh?
I'll give an affidavit.
My lord, it will better, my lord, if the both party will come, my lord, file joint affidavit.
Settle between both the parties.
Stepmother for that reason, my lord.
Which police station?
Sadar petitioner, Kota Sadar. Day after tomorrow.
They come, bring them at 2 o'clock.
आज भी है
Bring them at 2 o'clock, we'll do it. Or tomorrow, 10 o'clock, 10:30.
take instruction.
What instruction they have settled? You are for the mother, stepmother.
I am for the son.
Your son, then you are the accused. You have a reluctance. He will come.
Stepmother.
Huh? You bring him tomorrow. What is the problem? Do you
Day
have
after-
the problem or your client has a problem?
Client has.
What problem?
Day after tomorrow, 1 day after.
Day after? 19.
Friday.
Huh? First item. Oh,
Right.
passing 2 minutes. First item on 19.
Well,
Bring this.
Well.
Take on record their affidavit and all this. Don't ask for adjournment.
well.
If you ask for adjournment, then I'll dismiss. I'll take it that it is not settled.
आगुर कर दिया.
Yes.
28,
Village.
28.
My
Yes.
lord.
Yes.
Here, my lord, petitioner's husband challenging the order of annexure 5, page 40, my lord. Order of taking cognizance. Offenses shall lead up 498A, 294, 320.
You are the husband.
My lord.
Hmm.
323, 406,
Yes.
506.
So be
30.
the allegation in charge sheet.
Now, in what happened in the meter, this is the charge sheet, this is the cognizance order, my lord. My lord, both the husband and wife, my lord. They have, my lord, annexure 4 filed 13B petition for consent divorce, my lord. That divorce has been granted based on the statement of a wife that she will not pursue the case filed by her, and she has already taken the money, 5 lakhs permanent alimony, my lord. And everything has been, I filed, my lord, annexure 4, lord, kind of a glance.
Okay. Where is that sentence? In the
That is page 30, my lord.
30.
30.
That's right. Where is that sentence which you have?
My lord,
I have taken money and don't
Code
want to.
my lord, that is, my lord.
Polanda.
I have also filed affidavit or affidavit, my lord. That is annexure 3C is page 24.
Yes.
Paragraph
in
8.
In view of the mutual understanding, both the parties would take effective steps to withdraw the cases proceeding filed against each other. Okay.
8 number paragraph.
Where is she? She will come.
My lord, here, my lord, father of my wife is the informant. Wife is not an informant. Her father informant. My lord,
Father doesn't want to settle.
that is opposite party, not to I made a party, my lord.
They will issue notice.
But he has to implement the wife as the party.
Informant will party करे पड़ेगा. Informant
Informant था wife out होगा ना. compromise
wife କରିଦେନ technically
ଆଜ୍ଞା।
compromise ହେଇଯିବ ଗୋଟେ date ରେ ସରିଯିବ
ଆଉ notice
because
ଟା
she has in 13B she has made a very categorical
My lord, my
statement. I will withdraw it. But technically you have to do. in
ମୁଁ ଖାଲି
490.
ନାଁଟା ଚେଞ୍ଜ କରିଦେବି ଲର୍ଡସିପ୍ସ ଯଦି
ନାଇଁ, ନାଇଁ,
father
informant
ଥାଉ
will be
ଆଉ
there.
ଗୋଟେ କରିଦବ
Informant will be there.
3 କରିଦବ
Along with that,
copy 3 କରିଦିଅ
notice
the
issue
petitioner has petitioner has challenged petitioner has filed this petition seeking quashing of the cognizance order dated 12/3/2019 passed by STJM Pulwani in city case number 219 of 2018 under section so. ठीक है. Land council or the petitioner submits that the meanwhile the petitioner parties have settled the dispute amicably, full stop. In pursuance thereof, they filed a petition under section 13B of Hindu Marriage Act. Hindu
for
Marriage
consent
Act.
defense.
The learned family court, Pulwani, has passed the
Decree of
decree of divorce by mutual consent. In that proceeding, the victim wife has made a categorical statement that she doesn't want to proceed with any of the cases pending against her husband, her ex-husband, former husband, In the instant case, the father of the father of the victim is the informant, who is opposite party number 2. The counsel for the petitioner seeks liberty to implead the victim, namely the wife, as opposite party number 3. Issue notice to the opposite party number 2 and newly impleaded opposite party number 3, returnable within 1 week. 1 week. Let the party file a joint affidavit and before this court. Let the matter come up on 9th. 9th?
ଆଜ୍ଞା 9th of March, February. ଆଜ୍ଞା interim order ଟା my lord
Interim order to continue.
interim order last time it has come
Interim order ହେଇନି ନା କିଛି?
Interim order further
in view
proceeding
of the aforementioned facts and circumstances, the further proceeding in city case number so and so is stayed till next date of hearing.
obliged, my lord. I am permitted to
memory करे
implead the opposite party number 3.
Implead now.
Again.
Implead and Dusty, you want to take?
Just now I will, my lord.
Dusty copy. Service. Time over na?
Speed post na.
That is obviously. Will you take Dusty also? अरे भाबबार कोन अछि yes or no कहबे ए गुडे पृथ्वी रो बड कोन अछि yes कहबे न नो
दस्ती कले दे
नेबे तो दस्ती एज वेलकम
दस्ती सोनो पठे दो तो
29
in this case the FIR was initially filed under section 498 506 307 34 IPC and with section 480 Act.
Okay,
where the parents of the main petitioner, the husband of the victim, OP number 2 winner. The police has issued 41 notice against the parents, petition number 1 and 2 million. Charge sheet was filed, excluding 307 against the parents and 307 against the husband. But the court below took cognizance under Annexure 1 series at page 14. Order dated 2/2021 Miller at page 14. The court below has taken cognizance against the parents under section 307 Miller. A simple phrase of 41 notice was issued. Charge sheet was filed.
Charge sheet was filed exonerating but cognizance is taken.
Charge sheet was filed against the parents of the petitioner.
I understood charge sheet is filed against the parents of the petitioner without 307.
307.
Whereas 307 is invoked against the husband. Now the cognizance is taken against the parents also under 307. That's
All
what you
three
want to say.
and that's it.
Issue notice.
My simple phrase, I am surrender and go on bail 307 is there.
Oh, you want bail in this?
That will be the authorized patients, both are 65.
Maybe, but देखो, the petitioner has challenged the order dated 25/1/2021. 25/1 na?
25/1. No, my lord.
2/3/2021.
2/3/2021, passed by then court of SDJM Gunupur, whereby cognizance of the offence under section so and so has been taken against his client. He is put into cognizance. Taken. Full stop. He submits that initially, he submits that although in the charge sheet, the offence under 307, although against the husband of the informant, charges allegation against 307 IPC was invoked in the charge sheet, but insofar as the parent-in-law of opposite party number 2 is concerned, there was no allegation of 307 offense, allegation of offense under 307 in the charge sheet. However, the Learned Trial Court has taken cognizance against the present petitioners for the offense under section 307 IPC along with the other offenses. Therefore, he challenges the order. Full stop. He submits that the petitioners are senior citizens. They are already on bail insofar as during investigation they were 41 notice.
They have been served 41 notice. 41A notice.
41 notice under section 41 CRPC was given to his clients. However, due to the addition of offense, alleged offense under section 307, he is apprehending his arrest once he surrenders in the court. Susila judgment. He seeks to withdraw this petition with the liberty to approach the court below to seek appropriate remedy. Under the remedy as contemplated and appropriate remedy relying upon the judgment of the Constitutional Bench of the Supreme Court in Susila Devi so and so. The next paragraph. The petition is dismissed as withdrawn with liberty as spread. Liberty as spread.
My lord, objection may be made available the record. The 30, your lordship kindly have a glance to the charge sheet. There was not a iota of evidence against.
I have given everything to you. Go and get it. Susila Devi, I have written immediately. Look at it. And next, insofar as the petitioner also submits that insofar as the addition of insofar as the cognizance of offence under 307 is concerned, he would raise this point at appropriate stage of trial. Charge, you get the bail and argue on charge, you will be out. Dispute, with above objection. Dispose with dispose of with the above observation.
May I please? It's a matrimonial dispute, your lordship, and petitioners are the in-laws of informant, sister-in-law and her husband and brother-in-law before your lordship. This is a case, during dispute between the husband and wife, they have settled their dispute amicably, and thereafter they filed 13B application, Your Lordship, in the year
Where is
2012.
the?
That is at Annexure 4.
2012.
2012. Yeah.
Away
In the
with
year
them.
2012, they have filed divorce 13B
They are
application.
separated. They are separated.
But the wife did not cooperate the procedure, so and lost the FIR in the year 2015, Your Lordship.
After taking divorce.
After not taking divorce, because she did not cooperate the proceeding that
You
13B
say 2012 mutual divorce has taken place.
mutual divorce
No, my lord.
filed, Your Lordship.
That
not
is
taken.
that expert
Filed.
matter.
No, that is at the 2018. She did not cooperate with that proceeding, 13B proceeding, and lost the FIR in the year 2015, Your Lordship. And added all the in-laws, including husband, and in-laws, sister-in-law's husband and
In
brother-in-law.
2015.
In the year 2000.
What happened now?
Now charge sheet has been submitted and trial not commenced till date. But in the meantime, the husband got ex parte divorce from the wife. That is at Annexure 5.
That ex parte divorce is challenged by.
Not challenged, unchallenged, still date.
What is your age?
Allegation 498, general allegation, omnibus allegation against all the in-laws as well as husband.
You are the husband is
I am
Prasanna
the
Kumar Shetty. Husband?
Husband has not
husband is
come.
not come.
It is who is brother-in-law?
Sister-in-law, sister-in-law's husband and brother-in-law of sister-in-law.
So simply we will issue notice. Let us see if you can settle it.
No settlement because she'll not come after divorce and unchallenged that one. So
Charge sheet, when the charge sheet was filed?
charge sheet was filed in the year 2016. You understand?
What is the stage of trial?
The trial not commenced till date. No witness has been
Charge has
examined.
been framed. And
Charge has been framed. 19/7/2016 charges has been filed. Your Lordship.
what are you challenging then?
I'm challenging quashing of the entire proceeding against the in-laws. Your
A
Lordship.
charge has been framed. What is?
Charge.
I will simply issue notice. No question. Charge has been framed to approach. Trial is going on now. Charge sheet, quash the charge sheet.
No, trial not yet commenced.
But charge has been framed. You should have challenged the charge order.
Because these are the in-laws and there are so many
Charge has been framed
judgments.
against you. What I'll do is I'll issue notice. Let us see. We can persuade the opposite party to settle it. Because this trial will be in futility. According to me. We will issue notice to the opposite party number 2. Mr. Agada waives notice insofar as opposite party number 1 is concerned. Returnable within 2 weeks. 2 weeks. 20th.
More time.
Issue notice on the interim application. Interim.
No.
You have not moved in.
No interim.
Okay. Let us see. If she comes, then we will persuade her
Okay.
to finish it up. Okay. Yes.
32.
You should be, tell your client to be ready for some alimony, something.
Already alimony has given, also 1.5 lakhs has been given at that time in the year 2012.
That is mutual divorce. thing.
Yes. And
But in the ex parte, nothing is done.
nothing expert because he has taken all the amount thereafter.
She may not be interested at all.
Okay.
He may not be interested. Maybe. Yes.
32.
May I please, Your Lordship? Here is a case, my lord, I have challenged the order. Dated 30/11/2022, Your Lordship.
Yes.
30/11/2022, not allowing the petitioner to, my lord, to be dispensed with his personal appearance, invoking under section 205 of CRPC.
31, yes. 205.
205 application. Here, my lord, a complaint case was, my lord, instituted by the opposite.
What is the offense?
Offense, my lord, 420 and other offenses. It is a complaint case.
Where are you staying?
I am saying, Your Lordship, Your Lordship, may kindly come to.
Chandanpur. You are in district. Where is the trial going on?
Trial court, my lord, complaint was dismissed.
No, merit, I am not interested.
No. Trial court, my lord, complaint is dismissed. And subsequently, by the Honorable Session Judge, my lord, the order passed by the trial court was set aside. And it was directed to take.
Hey, what is in 205? Why 205?
205, your lordship, because he is the advocate clerk. And
Ad-
more advocate clerk. The petitioner is one advocate clerk.
So you should be happy to go there.
No,
You get
my
good
lord,
clients.
but his busy schedule is there. My lord, you don't know, lordship knows the advocate, the responsibility of
The
the.
lawyer is busy or the
My lord,
clerk of
advocate,
law is busy?
my lord, in Puri district, in fact, your lordship.
He's minting money.
No,
He
no,
doesn't
my lord,
want
the
that.
advocate, the advocate clerk is much busier than the advocate concerned.
Always advocate clerk.
My lord, my lord, the law says, your lordship may kindly see 205 CRPC.
What is his?
It says there is a clause 2. As and when required, your lordships, he must be compelled for personal appearance. That I don't have any dispute. But at each day, your lordships, that is attendance to be
See,
caused
if
by.
he is a stranger to the court proceeding, then he's scared or something of that sort, then he moves application. Why should I be humiliated? He is a clerk. He is always there in the court. What is the ego issue? What is the ego issue?
Nothing. Allegation against him is civil in nature.
Maybe, I don't know.
My point
That's
is,
not the point in challenge.
Whenever my lord 205 CRPC is concerned, your lordship may kindly say I may.
This is the court where, which court is this?
SDGM Puri.
Eh?
SDGM Puri.
No. You are in Puri and SDGM Puri, same court. You are a clerk of a advocate. You don't go.
I don't say, my lord, I will not go.
Go.
No, I will.
That is the whole difficulty.
No, my lord, 205 is not that, my lord, I will not go. 205 says, my lord, I will go. As and when required.
That's what
So that is 205. Your lordship may say.
That's right. That's right.
Your lordship may say.
Who is saying that every day you come and sit?
They say not disposing for personal attendance, my lord, says that you must appear in each and every day.
No.
That is not.
Your lordship
Nobody says that you every day come and
Order the accused persons can also take a recourse of section 317.
317. Why?
The lawyer will depend upon.
Why 317? Your lordship may kindly see.
If he religion well, then lawyer file 317 petition.
205 condition is your lordship may kindly see clause 2.
I think this is all ego issue.
Whenever a magistrate issues a summons, he may, if he sees reason to do so, dispense with the personal attendance of the accused and permit him to appear by his pleader. But the magistrate inquiring into or trying the case may, in his discretion, of any stage.
I could have, in fact, entertained this petition had it been someone else. Being a clerk of advocate, I will not hear it. He has to appear. Technically, you may be correct. I am assuming it to be correct. But a clerk of the same court, he is running around everywhere, and but he will not go to that court.
No. I don't say so.
I'll simply say that as and when required, he will appear.
Yes. Your lordship may say.
Simple as that. Why?
My lord, that is 205.
My lord.
He has to appear before the court.
Obviously.
And NBW has already been issued against him.
Naturally, I understood it. I understand it much. That is the reason he is showing me all the provision. He also knows. What to do? Sometimes you hold a difficult brief. The petitioner had challenged this challenge, the order dated 30th November 2022. Passed by HGM Puri in 1 CC case number. CC case immediately he'll get bail. Why is unnecessary not a bail?
409 is there, man.
Whatever, but he'll get a bail.
409 is not relating to me because someone has purchased the land. I have given the advice. The allegation is your lordship. Your lordship,
you are the clerk. And you are involved in extracurricular activity.
No,
that is why this case.
Only case is he has taken the advice from me to purchase the land. And I have given the advice that it is free from.
Being a clerk, you might have given a good advice.
So that advice will bring me to a case, drag me to a case. That is unfortunate.
You have a good extracurricular activity. Puri ICC case number 425 of 2019, whereby the application of the applicant under section 205 CRPC for dispensing his personal appearance has been disallowed. Disallowed. Mr. Mahapatra, appearing for the petitioner, submits that the petitioner is a clerk of a advocate practicing the court of district court of Puri. The present case is also full stop. The present case is also pending before the SDGM court of SDGM Puri. Therefore, I find no reason why the petitioner would not appear before the court. Having said that, the petitioner is at liberty. Next further. In view of the aforementioned facts and circumstances, I am of the opinion that the petition under 482 CRPC, the jurisdiction of this court is the intervention of this court is not called for. Also, having said that, the petitioner is required to appear before the courts as and when his presence is required by the court below during the trial. The petition is therefore dismissed.
Disposed of lordship.
Disposed of.
Dismissal will give rise meaning.
Disposed. And you get bail immediately if you pay.
Right.
34.
He must be a very smart clerk. He will do it. Don't worry.
No, the offences your lordship may kindly see, these are not at all made out. I should have challenged that cognizance.
So
because
that
what
is the
has
reason you will
happened,
get the bail.
and what has happened, the actual complaint was dismissed by the Law and SDG. A revision was preferred, challenging that.
Sessions
before-
court has taken this.
And the Law and Session Judge has said, no, but the offences are made out, you take cognizance. So after that, cognizance is taken. In fact,
Sessions judge must be knowing you well.
Item number 34, on behalf of Mr. Khan, bench for pass over.
Pass over.
Oblige.
35.
My lordship, item number 35 and 36. Password, my lordship.
Pass over.
Pass over.
37.
Pass over.
38.
Pass over.
37 ta pass over.
39.
39.
Pass over.
36 ta pass over.
Nobody wants to do 41.
41.
41.
Here, the petitioner is challenging the order of NBW, which was issued by the JMFC, by the Court of London.
When you got bail?
My lord?
When you got bail?
My bail, I've annexed at running page.
Tell me the date.
Date, my lord. Here is the copy, my lord.
40 copy mat dinanti.
NBW call.
Copy koda de diyantu.
You tell me the date you are throwing papers.
12/4/2010.
Huh?
12/4/2010.
12/4/2010.
2010.
2010.
Yes, ma'am.
And when the NBW?
NBW has been issued on dated 22/1/2013.
22/1/2013.
13.
13.
Yes, ma'am.
Achha. Where were you sleeping for 10 years?
I was working outside, so for my livelihood, so due to lack of communication between the petitioner and his counsel, could not able to know that the NBW has been issued. And when petitioner came to know the NBW order has been issued, so he approached this honorable court, my lord. That I have annexed at.
Why have you sought adjournment every time in this court?
Because my lord,
1, 2, 3, 4.
Yes.
4. Why?
because 2 dates I could not able to appear before due to some personal.
Or some hidden agenda?
No. My personal difficulty. And on last date, because I have taken adjournment.
What is the offense?
Offense under section 420, 294, 307, 506 of the IPC.
You must be absconding.
कितना number item?
Charge sheet has been Charge sheet has been filed.
My lord, charge sheet.
Obviously, charge sheet.
Yes, my lord, charge sheet has been filed.
Where is the impugn order? Let us see.
That is at running page 6 months.
82, 83 process has been issued.
82, 83 process has been issued.
31/7/2023.
Yes.
No, NBW is issued on NBW issued on
31/7/2020.
Huh?
31/7/2023.
31/7/2023.
NBW has been issued on 22/1/2013.
That is what.
Yes, madam.
Thereafter, no proceeding.
Yes.
What is he doing?
He's working outside as a working in a small factory.
Small factory.
Calcutta Road.
How much you will pay as a cost? It should be heavy cost. 10 years. How much?
2,000.
2,000 is so heavy. Yes, Mr. Maharaj. See the proceeding you see, page 6.
Yes.
On 22/1/2013, one proceeding.
One proceeding.
NBW was issued. Thereafter, no proceeding.
Yes.
Directly now. This is 82/83 proceeding.
से जो कॉपी सर्टिफाइड कॉपीटा जोटा मागी चोदी से डेट रो सर्टिफाइड कॉपीटा आछे
नहीं कंटिन्यूटी थियो ना मझिरे
ना कंटिन्यू आसीबोनी काना हमें जदी एप्लीकेशन दबा व्हेन वी आर अप्लाइंग फॉर सर्टिफाइड कॉपी we are mentioning the date
the proceeding
issuance of NBW and issuance of 82-83%. So that say dita date ro
आ भितरे कोन आइछि कि जणा पड़ि
ता भितर जणा पड़िबोनी काना unless until we see the LCR. But
in any case, you want to surrender and let him offenses.
Yes.
Will impose 3,000 rupees.
Yes.
Because it is a heavy delay. 3,000. Huh?
Advocate brief, so that's why advocate brief. So if
Okay, 500 we will reduce. What is the problem? Give it to the bar.
Yes.
2013. Now you are coming after 10 years.
Yes,
Still indulgence of this court. This is the only ground I could have dismissed your petition. The petitioner is facing trial. You are facing trial now?
Yes, ma'am. I'm facing trial.
The facing trial before the court of
JMFC London.
JMFC first class Soro.
Yes.
In Baleshwar under section 420 so and so. IBC. He was admitted to bail by the court below.
Paragraph 5.
Admitted to bail. Trial court has given you bail?
Miller High Court has given.
He was admitted to bail by this by this court by order dated 12/4/2010. Passed in VLAPL number 5788 of 2010. 2010. After having obtained bail from this court, the petitioner appears to have avoided appearance before the trial court, as a result of which the trial was stalled. Eventually, on 22/1/2013, the trial court issued NBW against the petitioner. The said order is under challenge. Even though the NBW was issued on 22/1/2013, the same has not been executed. Therefore, on 31/7/2023, the court below initiated the proceeding under section 82/83 CRPC. Petitioner submits that he would surrender to the jurisdiction of the court below forthwith. Therefore, the order dated 22/1/2013 the operation of the order dated 22/1/2013, 13, maybe state, maybe state, maybe state. Next program. Since the petitioner has approached this court after 1 decade of issuance of NBW against him, he is liable to pay a cost of rupees 2,500 to the welfare fund of High Court Bar Association. Next problem. Subject to paying the cost, the order dated 22/1/2013 is certified. Petitioner is directed to surrender to the jurisdiction of the trial court and cooperate with the trial court for speedy disposal of the trial. Speedy disposal of the trial. Meanwhile, the operation of order dated 22/1/2023 certified operation. He may do so within a period of when you will appear before the court?
Within 3 weeks, ma'am.
Within a period of 3 weeks hence. Disposed of. 2,500 deposit and appear.
Yes, pardon to mention, ma'am, I don't know 38.
30?
38, ma'am.
Passover.
Passover.
On behalf of Mr. Mishra, Imam Sankar Mishra, my letter.
But Passover at 2 o'clock.
What do you have?
You can't in between, you come and mention. No, maybe, but 2 o'clock only. Once I pass over, let us maintain the decorum of the court. Okay. Otherwise, what happens is there will be a chaos. It will be a fish market. Anybody will get in and do their case. Let us maintain the sanctity of the High Court. If it is maintained, what happens? It is good for you as well as for the court. Let us do it. Yes.
42.
May please, Your Lords.
Yes.
This is an application under section 482 of Code of Criminal Procedure. In fact, this matter has been heard by the another bench. Your Lordship, written note of argument was filed.
Oh, there are a
Judgment
lot
was
of
signed.
hearings.
Whatever it may be, Your Lordship, it is now before Your Lordship.
My lord, in this case, I am for the intervener, my lord. Just wait.
Yes.
Intervener.
I have already filed one.
Let us understand what he says.
I filed, my lord, one IA that is not listed before, my lord.
Okay. Let us see what is the case is about.
Already copy, my lord.
What do you want in this case?
Quashing of the entire proceeding because it is the abuse of process of court. Your Lordship. The sole question before Your Lordship is that whether in the same set of charges, when in departmental proceeding, the person has been exonerated from all the charges, 2 departmental inquiries by the government, Your Lordship, whether the self set of facts, the criminal proceedings shall be continued. This is the sole question that is to be decided by Your Lordship. And it has been settled by the Honorable Appellate Court and different coordinate benches of Your Lordship will satisfy what is the fact, Your Lordship. Because the FIR was lost on the allegation that the complainant has been cheated by one Bias Motors because he has applied for a tractor. Accordingly, the bank, he has availed
You are the bank officer.
No, mind. I'm not the bank officer. He has availed a loan by creating equitable mortgage. In spite of this, the bank has also sanctioned the amount in favor of the dealer. But the dealer has not released the tractor in favor of the complainant.
In favor of who?
In favor of the informant who has lost the affair, in spite of the fact that he has been sanctioned, the bank has sanctioned the loan and equitable mortgage has been created. This is the precise story.
The loan was not disbursed.
Loan was disbursed to the
dealer. But he has not released the vehicle.
He has not released the vehicle.
Okay.
Well, who am I, Your Lordship? All these persons are accused persons are facing the charges. Your Lordship, I have no problem about the prosecution of these persons.
Who are you?
I am the RTO. And my allegation against me is that I have submitted a report of a non-existent vehicle. On that day, because the duty of the RTO is to is under the MBI to inspect the vehicle, engine number, chassis number, whatever it may be. And on, it is the allegation that on that 17 vehicles were sent to the RTO for inspection. And without inspection, he has submitted a report. That is the self-same
Where
allegation.
this vehicle is also one of them.
Where this vehicle is one among them.
Hmm.
Listen. So this is what the allegation against me. So other accused persons that cheating, they are facing the charges. I have no problem about it. But basing on the same facts, when the FIR was lodged and the charge sheet was submitted. Charge sheet was submitted and your lordship, all the documents.
Cognizance is taken and.
Cognizance is taken, your lordship. My cause of action arose when, your lordship, the departmental proceeding was initiated basing on the FIR, your lordship, when the FIR was lodged.
Right.
The departmental proceeding, one of the charge is that, self-term charge. My allegation is that this is the charge. After a thorough inquiry, I have been exonerated. It was conducted by one of the IAS officer, your lordship, and I have been exonerated. The government didn't satisfy, your lordship. After 2 years thereafter, 2018, 2020, another inquiry was conducted by the government and another inquiry officer was appointed.
Pertaining to the same vehicle.
Pertaining to the same charges, same vehicles, and same set of cause of action, your lordship. In 2022, one Sanjeev Panda IPS officer was the inquiry officer.
Again, you are exonerated.
Again, a due inquiry was held by the esteem inquiry officer, and I have been exonerated by the officer and whose has been exonerated, your lordship. That I have annexed all the documents.
Right.
After that, your lordship, after submission of the report, and it has been accepted by the government, your lordship, I have filed an application before your lordship seeking the grievance that the FIR which has been lodged at least against me
should be quashed.
May be quashed because the prosecution before the lower court against me for the offences under section 467 and other offences is shall not maintainable because ultimately I will be acquitted. Your lordship, whatever and maybe. And there are a host of witnesses are there. And it will take a lot of time, your lordship. And I am a government servant, your lordship. Now the government servant, your lordship.
Why have you taken adjournment in so 1, 2, 3, 4, 5, 6 days?
My lord, I have not taken the time, your lordship. My lord, my esteemed colleague who is
Who are you?
Well, who is filing the intervention application here.
But I tell you.
On the very previous day took the time.
Okay.
What is the locus standi? And your lordship,
We'll check, we'll see that, but the standard of proof in a criminal case and the departmental proceedings are different. And
Right.
you might be relying upon those judgments where there is an adjudication proceeding in
Hon'Ble.
FERA and all. There the court says that if there is the adjudication proceeding, you can't bring parity with a exoneration in a adjudication proceeding. Suppose a FERA violation is there or copy posa violation is there, there is an adjudication process and criminal prosecution goes. If you are exonerated in a adjudication process, then criminal proceeding has to be stopped. That is the law. But you can't bring parity with departmental proceeding with
My lord, departmental proceeding, adjudicator proceeding is the self and key in my lord. Well, I am having all the judgments. I am having all the
I know you would be citing those judgments.
My lord, Supreme Court 2 judgments, Radheshyam Kejriwal's Asunath theory.
I know this.
And then there is coordinate after that Supreme Court judgments, our
adjudicating authorities exoneration or in the appeal exoneration by FERA board or copy posa board is altogether different. The standard of the criminality has to be gone into in those proceedings. And since in those proceedings the standard of proof is more or less the same, and these are the summary proceedings.
Yes.
So therefore the court says that in the summary proceeding you are exonerated. So therefore the criminal prosecution is a futile exercise. So therefore, quashed. But departmental proceeding is altogether different.
On this point, well, I am totally agree, your lordship.
Can you give me any judgment?
Well, I have having the judgment, your lordship have also filed, it has been recorded, paper book, your lordship, I have filed
Now you show me one judgment where departmental proceeding is
my lord,
taken.
our own High Court, but taking Justice yes, more and there passed the judgment.
Yes. Show me.
Highly
You have given the copy to.
My lord, I have given the copy to my.
I have also given the honorable
That
apex
is there,
court,
short notes of the
citation.
precedent,
My
yes.
lord, I am just.
By the way, what is your role?
My
Who
lord,
are you?
I am just.
My lord, I am
One
the
minute, 1
victim.
minute. Let
My
us
lord-
understand.
My lord, I am the victim, my lord.
You are the.
Victim and informant, my lord. My lord, this case started after a writ was disposed of by this honorable court, and there was a direction for investigation. CID-CB. Thereafter, charge sheet was filed. Initially, I have not lodged FIR against this person. But after investigation, my lord, CIDCP charge sheeted this person. And in the meantime, there are at least 2 witnesses examined in the trial, my lord. And there are 40 some odd witnesses are there still to be examined, my lord. There is, my lord, criminal allegation.
Trial is going.
Trial is going, my lord.
Well, may I submit?
In such circumstances, my lord, interface
sir.
very bleak.
Yes.
Yes.
My lord, I am not disputing. My lord, from the beginning, I have said that my cause of action, my locus before your lordship started after then your lordship, Bhajanal case, your lordship, cover your lordship, because there are host of witnesses are there. 2 witnesses have already been examined, your lordship. 2 witnesses. Ultimately, your lordship, the case shall, it is a longer process, your lordship. My lord, what, your lordship, I have paper book, your lordship, just have a glance. The judgment of our own High Court, the court note, after taking note of Radheshyam Kejriwal and Radhesh Asunath theory, your lordship.
You are relying upon this.
Meenaketan Pani.
Pushparaj.
Meenaketan Pani, your lordship, first, your lordship, just have a glance about the Bombay High Court judgment 95 Supreme Court. My paper book, flag 1. Flag 2, your lordship, this is the Bombay High Court judgment. Flag 2. 2007 for Bombay CK 162 Bombay High Court. My lord, got it that?
Bombay.
Bombay High Court.
Hemendra Kumar Kothari.
My lord, Hemendra M. Kothari.
Yes.
My lord,
Which paragraph?
Paragraph, your lordship, I'm just showing you. Paragraph 21, my lord, just having. Paragraph 21.
Yes.
My lord, got it? Paragraph 21.
Yes, yes.
My lord, it may be noted that in the
20.
present case, the
21.
applicant was exonerated by the enforcement director.
What is which page is it?
Number to kitchen.
My lord,
21. It may be noted.
it may be noted. My lord, got it. It may be noted that in the present case, the applicant was exonerated by the Director of Enforcement, who was adjudicating authority in the adjudication proceeding.
This is not applicable. Next.
Thereafter, your lordship, that this judgment has been approved by the Honorable Appellate.
That's right. But
Radheshyam Kejriwal's case.
that is the enforcement directorate.
My lord.
Adjudication process.
My lord.
I am telling you without referring to the judgment, I know. On tips.
Radheshyam case. My lord, that's all.
You show me one judgment where departmental proceeding is taken.
Then our own High Court, your lordship, flag 5.
Huh?
Flag 5. Dr. Meenaketan Pani.
That show me that. Radheshyam is exoneration by the adjudicating authority.
Then also subsequent judgment, Justice Nariman's judgment, Asunath theory's case, that is also.
Again, that is exoneration.
That has been relied upon.
That is exoneration in adjudication.
Then your lordship, flag 5, your lordship, that is reported 2022 2 OLR. That is Meenaketan Pani versus State of Odisha.
1 minute, sir. Let me catch hold of that judgment. You have filed all the documents on that exoneration only. Exoneration. Again, this you are relying upon this. Meenaketan Pani. Which paragraph?
My lord. Well, I'm just showing you. Paragraph 4. Paragraph 4.
On receipt of the above
information, an inquiry was conducted. During inquiry, it was ascertained that the marks of Sri Sibo Sankar Das had been tampered, manipulated, and enhanced at the various lips of the officers to give undue advantage and favor to him. It was suspected that the marks of other candidates also might have been similarly tampered and manipulated. Accordingly, an FIR was registered and consequently so. Then investigation was conducted. Paragraph 6, investigation undertaken. Paragraph 9. Paragraph 9 deals with the report of the inquiry officer. Well, the departmental inquiry was conducted. Thereafter, paragraph 10, the petitioner was therefore censured since the main charges were not proved and the period from so and so. By an order dated 30th March, OAT tribunal disposed of the appeal, the Department of Higher Education, so and so. Thereafter, your lordship.
Yeah, read that. That's very relevant.
My lord. Paragraph 11, my lord.
11.
By an order dated 30th March 2013, the OAT disposed of the appeal. The Department of Higher Education then preferred a review against the above order dated 13th March 2013. However, the OAT by its order dated 20.
So this is the test.
My lord.
It was the departmental exoneration.
My lord.
Was subjected to the scrutiny of the court of law.
My lord.
And it was confirmed.
My lord.
Therefore, the court says, so it suffered the scrutiny of the courts.
Yes.
That is CAT, thereafter High Court, thereafter Supreme Court. So therefore, it got the seal of approval.
Right.
And then the court goes and says, so on this background, we am passing.
My lord.
But in your case, only the
departmental. My lord, the departmental on this text, the departmental proceeding has been exonerated, your lordship. Then
exonerated and it was subjected to judicial scrutiny by the Central Administrative Tribunal and writ petition, thereafter Supreme Court.
My lord.
And it was confirmed.
My lord. Well,
therefore, the court says that since it has undergone a judicial scrutiny and it has been confirmed, so therefore, on that basis, the trial which is going to be conducted is a futile exercise. So therefore, it's fine.
Well, after my exoneration, who is to challenge? Well, the government has to challenge. Government has not yet challenged the taste of the exoneration has not been challenged by the government before any of the authority.
Any other judgment you have?
Anyway, well, in this paragraph, your lordship, Radhesham Kejriwal and Asuna Tiwari's judgment has been relied upon by the Honorable Chief Justice of our own, the then Chief Justice. Next paragraph.
Radhesham
and Asu Surendranath Tiwari. Next, paragraph 13. It is in the above paragraph 13. Next page. Departmental proceeding vis-a-vis Radhesham and Asuna, your lordship, adjudicating authority, your lordship was said. I have got it, that relevant para. My lord, I was showing just the applicability of the Radhesham and Asuna Tiwari's case vis-a-vis the departmental proceeding. One judgment, that is, my lord, Ajay Tyagi's case, that has also been taken up, which has been relied upon by the Eastern State Council. That has also been taken up in paragraph 14.
Yes, I have seen it.
My
That
lord.
judgment I think.
Then, my lord,
Where is that order by which the High Court has passed directing the CBCID to inquire?
My lord, this is how the case has been initiated, your lordship, just a glance. The complainant, my lord, sent a registered post with a writ to the police for registration of the FIR. When the FIR was not registered, the complainant filed a criminal writ petition before this honorable court.
Where is that order?
And this honorable court has directed.
Where is that order?
My lord,
Show me.
by page, your lordship,
relevant page 26, madam.
Page 21 to 34. It starts from page 21. This is FIR, and the order is at page 26, my lord, just a big glass. Page 26. This is what the order 26. 10/12/2007. 10, my lord, got it?
Read that.
My lord. High Lord and Council. The petitioner has alleged that he was granted loan by the State Bank of India, Ganjam branch, Ganjam, for purchasing the tractor and deposited the margin money by way of making payment to the dealer, namely Mrs. Basi Motors, the authorized dealer of Sonalika brand of tractors, and thereafter the bank has made payment directly to that dealer, but the tractor was never supplied to the petitioner. In the counter affidavit filed by Sri Padmanabha Tarab, branch manager, State Bank of India, Ganjam branch, on behalf of the opposite party number 123, it has been alleged that the allegations made in the petition show that how cleverly the petitioner has attempted to defraud the bank loan in a planned manner, either himself or in connivance with the dealer. The petitioner has filed a copy of the letter of one S. Nanda AGM marketing Orissa of Sonalika tractors, a copy of which is annexed as Annex 46 to the petition, in which it has been mentioned that one Sonalika tractor model number so and chassis number so was sold by their stockist, Mrs. Sujata Corporation of Bhubaneswar on 13/10/2006 to their dealer, Mrs. Mahalakshmi Motors, Sundargarh. And the said tractor was finally sold by their Sundargarh dealer, Mrs. Mahalakshmi Motors, to Mr. Jogendra Vaidar, Lefri Pada district, Sundargarh, on 2/12/2006. It has been alleged in the petition that the petitioner has sent a FIR to the IG of Police CIDCP Orissa Cuttack on 26/3/2007. A copy of which is annexed at Annex of 31 to the lead petition, but the same has not been registered so far. Mr. P.K. Pondalan, Standing Counsel Transport, has informed this court that the vehicle in question has been registered at two places, that is Sundargarh and Ganjam. Considering the facts and circumstances of the case, we are of the opinion that the matter be investigated by the CIDCP, since an FIR has already been sent by the petitioner to the IG of Police CIDCP on 26/3/2007, Annex of 31, it is provided that the same shall be registered under Section 154 of CRPC, for which an order shall be passed by the IG of Police CIDCP Orissa Cuttack on filing of a fresh copy of the same by
Yes.
Well, basing on this manner, the criminal prosecution started. The prosecution launched. Your Lordship, after the FIR was launched, Your Lordship.
Where is this your
Mine.
inquiry report, first inquiry?
Mine.
Annex 7. Show me the relevant part. Where this vehicle, regarding this vehicle.
Page 1040.
Which part?
And taking little bit of time, Your Lordship.
Only this vehicle, regarding this vehicle.
My Lord. Annex 7, it is at page 105. 105.
Yes.
This is the inquiry report submitted by the Additional Commissioner of Transport on 20.
Yes. Read the relevant part.
My Lord. Next page 106.
Relevant part.
My Lord.
Which is the vehicle number?
Well, first paragraph ka ito pad dochi.
First vehicle number you tell me.
Vehicle number is tractor and trailer by registration number OR07M1729 and OR07M17.
There are two vehicles.
Yes. Tractor and trailer. Tractor, like that. Separate number.
Okay. Two
So
vehicles.
it is having two numbers.
First paragraph.
Well,
Read it. First
Well,
paragraph.
first
Inquiry has
paragraph.
been made in person to the order so as per the article of charges, Sri Sanjay Kumar Behra, that is you, working as MBI so Ganjam, has submitted the inspection report of registration number so as the direction of the High Court Orissa CBC number so registration Sanjay Kumar so in course of investigation, prima facie evidence has been found against Sri so for the offence for which the case is likely to be charged. Next, come to the point. Statement, imputation, misconduct of described so.
the voluminous inquiry report because he has
You relevant part you read.
Lord,
In 482 can't
Lord.
examine everything.
Lord,
Relevant part.
all
As per the inquiry report submitted by
ସେଇଠି ଅଛି ସେଇ ପାରାରେ ଅଛି ବସ୍
you
ତାର ସେକେଣ୍ଡରେ ଅଛି
କହିଲି ସାର୍ ଆପଣ କହିଲି ସାର୍ ଆପଣ କହିବେନି
relevant parts different na.
My lord, I don't have copy of that petition, my lord.
Why I have not read it? Why you need the copy? Man, he is having the brief, your lordship.
Yes, sir, I have applied for certified copy of the petition.
My lord, page 127. Observations and opinion of the inquiry officer.
127.
127.
127. Okay, come. Read it.
It ends with page 131. The observation and the finding is at page 131. 131.
Read it.
My lord.
Yes.
My lord,
In view of the above, it is established that the Behera
had
not inspected the vehicle in question,
which have been issued with fitness certificate number so but inspected by Sri L.P. Patnaik on that day. In 15 cases and 2 cases, buses were jointly inspected by DCP so and NVIC as verified from the inspection check slips, which has not been verified at all by the DSP CIDCB. Well, as for generation of computerized fitness certificate password necessary, which were with Sibera and had not shared with NVIC after an FC was issued under the ID and password of Sibera has and he is countersigned the check slips as a token of acceptance of the check slips as FC had been issued with his ID and password.
They say that you have not checked, one Patnaik has done it.
Yes. My lord. On that date, another person was checked the vehicle.
I understand it.
Well, under the above circumstances, last paragraph. Under
Yes.
the above circumstances, in view of the documents produced and deposition of the witnesses and marshalling officer, the charges framed against the delinquent officer, say so and so, at present working as RTO Bhubaneswar are not sustainable, and hence it is recommended the CISA may be exonerated from the charges. This is the
You
report
want to, Mr. Maharaj,
My lord.
you want to point out anything from this report?
My lord, it has been
Well,
clearly
there are-
mentioned, my lord. That is the page 131. Further, Sri R.N. Mahapatra, DSP CIDCB, the investigating officers, Sri Vishal Vaisya, the complainant, and Sri Malket Singh of Mr. International Sonek Tractors did not appear before the inquiring officer in spite of 3 dates. The report's complaints could not corroborate as such further, and the inquiry has been completed without the deposition as a matter of natural justice. My lord, the question of the decision of the apex court, how
Well,
this is
thereafter, yes.
separated.
No, decision I understand it. That decision will not help. Only I
Yes.
am examining Justice Muralidhar's judgment
Yes,
where there is some parity drawn.
yes,
Some parity drawn, but it is distinguishable because it was subjected to judicial scrutiny.
Yes.
I am not on that. What I am saying is here also, it says that the police inspector, the IO and all, they were not examined. DSP crime branch has not been examined because he did not appear in department.
yes.
So
He
it
tells
is
us
he was not
actually
investigating the case.
unilateral, this thing.
Madam, may I submit another one thing?
Which are the 2 witnesses which has been examined, those who are examined right now?
Then most particularly, my lord, now situation is, my lord, the trial is going on.
No,
This is the very
2
most,
witnesses have already been examined.
Examined.
Who are they?
to my instruction, I don't know, let my brother may say.
And next report, next inquiry
After
report
that,
is?
your lordship, in 2020, next page, 132. Annexure 8 series. your
Second one.
Second inquiry was conducted on 6/10/2020. In pursuant of the inquiry report submitted by Samir Kumar, my lord, sorry.
What was the necessity to have a second inquiry?
That, my lord, actually, it was not within my knowledge why the second inquiry was initiated, why have been called upon to file the show cause. That, however, my lord, inquiry is conducted, I have participated in the inquiry throughout, second inquiry also. And my lords, the second inquiry, the inquiry officer was the special secretary to government appointed inquiry officer, and one Sanjeev Panda IPS was the inquiry officer. Page 136, Annexure 9. Annexure 9. At page 137. At page 137.
Come to 137 and para 2.
Finding-
Genesis of the article of charges against
Why?
Sanjay Kumar Behera
Why?
starts with the first information report so
CID
which has been registered with the written report of one Vishal Vyas against 4
Four
persons named by name And the official of
SBI Ganja.
charges and so on.
Well, here I will pause, Your Lordship, the officials of the SBI are the accused person, they are facing the charges.
On the cross examination of the delinquent officer.
This is also voluminous.
Find it. Prove that the charge officer has performed official work.
Conclusion up to 145.
Returning to the office on the above date, and he also proved that to the charge officer arrived in the office at conjoined the respective report and
Your Lordship may kindly turn to
140, come to 140.
140.
140 come.
Yes, 140.
In the first occasion, the DHP was not examined, and the second he has been examined.
Yes.
And so and so, and this has been
Yes.
investigated, and they was registered and supposed to mark discharge, and so with mark and signature, so this is the investigation, examine witnesses, from the report of BGM legal, the report article was never issued by their company.
Second paragraph.
And it was first one. The said report has been marked at the signature of BGM. They also wrote the report from RTO Sundargarh, which was you were RTO Sundargarh that time.
I was
RTO.
My lord, MBI at Chhatrapur.
MBI Chhatrapur.
MBI at Barampur Chhatrapur. At that time.
MBI.
Right.
Jagat Singh
MBI.
Jagat Singh Court without taking any leave of the headquarters, leaving permission, surrendered with the report of investigation in this connection with the own case was used on bail on the same day, Yet also issued fitness certificate to 17 vehicles, commercial vehicles, and without physical
This complainant was also examined, madam. Next page.
See, page 140, you read the first paragraph, last 5-6 lines. That is enough for you.
In
Face the
connection
trial.
with the above noted case and was released on the same day.
Face the trial then. Just see, read it. He further stated that this is the examination of R.N. Mahapatra, the DSP, and your role is reflecting from there.
My lord.
Just read it.
See, R.N. Mahapatra.
Read the 5-6 line and end. The said report has been marked as read it for your satisfaction. Read the full.
I'm not reading from on examination in has stated that he will be charge of investigation.
Read the full, no problem. For you.
Of CID CBPS case number 24 from Sri GK Parija, the then DSP CID CP and investigators into the above FIR was registered by Sri Santosh Kumar Vishwan so which has been marked as Exhibit 19 and the signature of Vishwal as Exhibit 19. During investigation and examining the witnesses and ascertained from the report of the DGM Legal International Patrol Limited that form number 22 was never issued by the company and it was false one. The said report has been marked as Exhibit 20 and the signature of DGM in Malakat same marked Exhibit 28. He also brought the report from RTO Sundargarh which has been marked Exhibit 21. He further stated that the charge officer Sri Behera was
Charge officer, yeah. It further stated that the charge officer Sri Behera, while posted as MBI Jagat Singhpur, without taking any leave or headquarter leave permission, surrender before the court of SCGM Barampur on 23/12. 1 minute, read it. 23/12/2010. In this connection with the above noted case and was released on bail on the same day. That is on 23/12/2010. On the same day, kindly see, on the same day, he had also purportedly issued a fitness certificate to the 17 commercial vehicles without physical verification as he was present in Barampur. You have taken bail in the Barampur in some other case. You were there on that day. You are issuing the certificate on the same day.
That is what the answer.
That is
when I just this is what the Well, when I was releasing on bail on that court, how it will be possible to issue the fitness certificate? It was issued by somebody else. What has been held by the inquiry report?
That is the test in the trial.
My lord, it has been held by the inquiry report itself, true to inquiry. Well, this is what the statement. Your
IO says something else.
Well, thereafter, your lordship, the finding, your lordship, that some second inquiry officer, it is at page 144. This was also a charge before the inquiry officer.
Show me the fitness certificate.
Fitness certificate where, your lordship, I will get, your lordship, because
Show
on
me the fitness certificate.
because on that date, your lordship, I was not holding the
Show me
office.
the fitness. I want to see in my eyes whether your signature appears what.
Fitness certificate, your lordship, where I will.
That's the whole gamut of the entire case.
Because, your lordship, my grievance before your lordship is there.
You might not have issued. I am understanding that. But am I not entitled to see
But
that? Yeah, entire cases is hinges upon the fitness certificate which you have alleged to have given it. Where is that fitness certificate on record? Let me see.
That fitness certificate which has been alleged against me, it is stated by both the inquiry officer that
I
on that
understand,
I
sir.
have
You are not
received the
present.
certificate.
This much I can understand. You give that credit to me.
Another thing, your lordship may kindly turn to 147 page, 147 last
I
line.
just want to see the fitness certificate, whether
But-
your signature appears or not. And you have the benefit of two departmental inquiry report where they say that one Aran Patnaik has done it, you have not done it.
Yes.
My
That is what says.
Ellen Patnaik.
And Ellen Patnaik.
My lord.
And whereas the IO Mahapatra
Hmm.
in the departmental proceeding and comes and says that on that particular day he was there in Barampur, he was availing bail. So therefore, a fitness certificate was issued by you. So I want to see the fitness certificate, whether you
My
are
lord.
issued or not. As
My
simple
lord.
as that.
My lord.
If you have
In-
not issued, I will pass it
My
right here.
in the total two inquiry, your lordship, all these questions which is put by your lordship,
This-
it has been answered. your
You
lordship.
know,
It has been stated.
you know by now, the standard of proof in a departmental proceeding and the standard of proof in a criminal prosecution are different.
Well, I'll
Different.
give the answer.
Let us see
Well,
what
I'll give the
147
answer.
wants.
He has not been.
Then there is no end to it.
My
We
lord,
keep on
free-
hearing.
147 last pair.
Ponderance of probability in
He's
department-
showing something. He's showing
My
something.
147 last pair.
My-
Whereas after careful consideration of the findings of the inquiry officer,
Hmm.
well, very important, finding of the inquiry officer in respect of the charges leveled at him, government have been pleased to finalize the disciplinary proceeding with the warning to the delinquent officer, Sri Sanjay Kumar Behra, to be careful in future.
But next page, next 149, your lordship, 149 page, your lordship.
But this is just a
This is the
departmental
government
proceeding,
has
and he has been
149,
given one
annexure 11, your lordship.
because of the consideration of the evidences.
I have been completely, the Under Secretary of the Government.
And
issued
your
a
lordship
letter
rightly
that I have
pointed
been
out that
completely, the lady was
paragraphs.
completely exonerated from the charges.
No, you are not
149.
completely generated.
But page formal subjected to your lordship's interpretation, your lordship, page 149, my lord, just a minute. Annexure 11.
সেটা তো তার রুল সেটা সেটা লিখিও বাধ্য হবে দ্যাট ইজ এ প্রসিডিওর
Annexure in government, it is implemented to the government, to the.
Just see.
My-
Come to page 145.
Yes.
140.
Second report, final second report. Just see what is the finding.
Mine.
Ultimate finding is,
Mine.
just see.
Mine.
Second, Mr. SK of the charge officer SK Behra
My lord.
returned to the office of SDGM Court Barampur at 5 p.m.
My lord, my lord,
on 23/12/2010.
Yes.
Performed his official work.
my lord.
He also proved that charge officer, after arriving at the office, had countersigned the inspection report
Yes.
in respect of 17 vehicles.
My lord, charge
And
officer.
which were, you are the charge officer. What are you talking? You are the charge officer.
My lord.
Who is the charge officer?
all the inspection and runs from.
and which were inspected by L. Patnaik, MB, and thus the charge that the charge officer had purportedly issued the fitness certificate to so vehicle
17
could not be established. Could not be
Yeah.
established. That means
Conclusion.
Patnaik has given it, you have countersigned.
Countersign.
My lord, conclusion. Your
And
lordship.
the rest part is to be
Conclusion. Your
tested
lordship.
in the trial.
Report is.
You have
Conclusion, your lordship, just a minute, conclusion of that report. This is what the finding.
you want expeditious disposal of the trial,
My lord, I want, my lord.
or I'll reserve the judgment and pass it.
My lord, that is my humble service. My humble service.
But some observation may come and
Another judgment, your lordship, I am citing Pushpara's judgment. After that, Radhesham and Surendranath Tiwari, Justice Muralidhar and another coordinate bench of this court in 2023, 28 to 2012.
Radhesham will not help, sir. Radhesham is
Radhesham has been taken note of.
education process.
Very
Well,
applicable
Radhesham
decision is,
and-
my lord, NCC Delhi
Well, that has been
versus
taken note
Ajay
of.
Kumar.
Muralidhar says,
Tyagi.
I'll derive the principle of Radhesham.
My lord.
Radhesham is only saying that if there is an adjudication proceeding and you are exonerated, the criminal prosecution needs to be quashed because the exercise is a futile exercise.
My lord.
Because standard of proofs are different. But here you are relying upon two departmental inquiry report where the department is also doubting the very fact that the fitness certificate you are issued, you say that somebody else has done it. Yes, somebody else has done it. That is finding has come. But you have countersigned. Coming from Berhampur, after availing at 5 p.m., you countersign it. What was the intention of countersigning?
Yes.
That is the
but
test.
had-
That is the trial which
Well,
you have to undergo.
Well, had it been so, the conclusion of the two reports of the inquiry, at least I should not have been completely exonerated. I should have minimum punishment must have been
It is there.
Had it been so.
It is there.
And the government has not challenged all these proceedings.
Now just see the order 8/8/2023, 147.
Well,
Last line.
147, my answer is at 149. Subsequently, the government has clarified that you have completely exonerated from the charges. My answer is at page 111.
That is in so far departmental proceedings.
That is, my lord, this departmental proceeding, Madam Dr. Minakatan Pani and Justice, another judgment, your lordship, Pushpara's judgment, your lordship, it was decided on 28/2/2023. Departmental inquiry. Vis-a-vis the applicability of the
See,
Radhesham.
147, that last line warning is there. Huh?
Well, that's
And
why-
you ask for clarification. In the clarification, they say that there is no department.
What the
Just
same
see,
government,
140
this same government has clarified it, 149.
See, the 147, the warning is not described either it is a major penalty or minor penalty.
Yes.
It doesn't come under the minor penalty.
Minor.
So therefore, when you ask for a clarification, they say that you have exonerated, there is no penalty. That's what they say.
That's what to say.
That's what they
That's
say.
it.
But-
That's the procedure.
but warning is there.
My
I see.
question.
That's make difference.
Then when there is a warning, well, whatever it may be, well, it has not been challenged by the government anywhere. My executive complete execution. When the government has not challenged, can it form the basis of one of the basis of conviction in the departmental inquiry? Punishment. Well, punishment, my lord, know that service matter. Punishment, when I have been not punished, can the same document be categorized as one of the punishment in the departmental inquiry?
No, it's not a punishment. You have given warning.
Warning there.
My lord,
We
Punishment
can-
bonus.
warning. Thereafter, when it was a warning, then I have represented on the government has clarified that no, you have been completely exonerated.
Okay, you have already given your written submission.
My lord.
I'll just see.
And one judgment, another judgment on Pushpara's judgment. Court. But after the Supreme Court judgment.
Pushparaj, you have filed, I know,
Well, I
I've
have
seen
filed.
it. I've seen Pushparaj, you have
What is
filed.
the approach of
Only one
different-
question, your lordship, I have already given. That is State of NCT of Delhi, Ajay Kumar Tyagi
My lord.
versus Ajay Kumar Tyagi. The relevant portion I am reading just. We are
After that,
therefore
we have
opinion
taken
of.
note of.
Ajay Tyagi.
Let me 1 minute.
Yes.
We are therefore of the opinion that the exoneration in the departmental proceeding ipso facto would not result into the quashing of the criminal prosecution.
Ajay Tyagi.
We hasten to add, however, that if the prosecution against an accused is solely based on a finding in a proceeding, and that finding is set aside by the superior authority in the hierarchy, the very foundation goes and the prosecution may be quashed. But that principle not apply in the case of the departmental proceeding as the criminal trial
Para?
and the para, my lord, this is not noted in the, so far the para is concerned.
Which page?
Page 17. Page 17.
My answer is.
And
that-
the
Let's see what-
Pushparaj, which paragraph?
My Ajay Tyagis case has been taken note of by Dr. Justice Muralda.
And in this decision, everything has been taken note of.
My lord put a question.
Pushparaj, which paragraph?
My lord, Pushparaj paragraph 7 and 8.
Tell me, Pushparaj.
My lord. My lord, shall I read your lordship? The question is whether the criminal prosecution vis-a-vis the petitioner is to be quashed due to his exoneration from the charges leveled in the disciplinary proceeding. The law will settle that a disciplinary action is independent and exclusive and can continue irrespective of the criminal action and vice versa. The outcome of the disciplinary proceeding is not to influence the result in a criminal trial. So to say, the decision of the
Ajay Tyagi is
Ajay
taken note
Tyagi's
of.
case has also been.
Radheshyam is taken note of.
My lord.
Thereafter, what does it say?
My lord.
Ripa Sharma is also taken note of.
My lord,
What
in paragraph 12, the CRL MC is allowed to quash, the proceeding was quashed. Radhesham, Ajay Tyagi and Surendranath
the
Tiwari.
test is in
Right.
para 8.
Paragraph 8.
Para 8, last 3 lines.
Last
In such situation, it is found by the authority
My
that the charges could not be established
My lord.
or the department miserably failed to prove it.
Yes.
Okay. In such situation,
There
since
is
there is a remote possibility of any evidence
My
to
lord.
surface
Hmm.
during the criminal trial,
Set of the man.
where the standard of proof is higher,
My lord.
it should not be allowed to continue
My lord.
and which should result in abuse of process.
My lord. My lord.
And in the
my
instance case, that is not the case.
I am answering. My lord. My lord, the standard of proof in a criminal case vis-a-vis standard of proof in the department of proceeding. When these officers and these witnesses stated in the departmental proceeding didn't believe it, then the criminal proceeding is not on the standard of proof is quite different, your lordship. I have nothing to prove in a criminal case, your lordship. I have nothing to prove. It is the prosecution to prove the case against me beyond all reasonable doubt. In the criminal cases, they can set all these witnesses. I can also replace all these evidences in the criminal cases, your lordship. I am not required.
How many
to prove
witnesses
anything.
you have cited?
2 na 3.
Cited witnesses.
Total cited 40.
40.
Yes.
How many you will examine?
ସବୁଗୁଡା କଣ examine ହେବେ ତା ଭିତରେ
How much time will you take?
maximum
Because he has a solid defense.
45.
FIR is of
2006 year lordship.
2006.
2007.
2007. Sorry,
18/12/7.
See, 2007 FIR, he suffered 2 departmental
Yes.
inquiries. And how much sufferance one has to undergo?
Within a period of 6 months, your lordship.
Not 6 months. Why 6 months? 3 months you conclude.
The time.
You conclude it 2007. He is not stand in your way. Who stopped you to complete? When the charge sheet was filed?
Charge sheet was filed on
Charge sheet.
filed on 18/3/2008.
2008. What are you doing?
Lordship,
Wrongly or rightly, somebody has unfortunately got stuck in some technical issue. So therefore, he had to suffer the 2 departmental proceeding. And today he is suffering this criminal prosecution from 2007. How many years, just see?
My promotion, your lordship, has been held up.
That I have given a judgment. That complaint you don't have. At least in this court, I have said that pendency of these cases will not stop your promotion. You can that.
That order, at least maybe I.
In a 482 quashing petition, I will give you promotion.
My lord, it shall not be bad. Criminal proceeding, it shall not be bad to, my lord.
That judgment I have already
My
given.
lord,
Sir,
I
you
know
just see
that.
the judgment.
My lord, no, I know that your lordship is sitting in 482. My lord, another bench, your lordship, I have.
That judgment, you can't take that benefit. That judgment very clearly I have said, the prolongation of the trial will not take away the rights of consideration. Promotion is a consideration only. You can't get the promotion, right to be considered.
What my humble
You will be
submission is
considered.
that judgment may be taken note of. And that judgment.
And I give you promotion.
Not promotion. The department, my lord, and what my humble grievance is
You
that.
decide whether you have come for quashing or promotion.
No, quashing, your lordship, quashing is the very purpose of my application, your lordship.
See,
and
in,
my
a,
lord,
in a 482, I have seen the plight of yours, the way you suffered. I can see through the documents. You have really suffered a lot. What in 482 court to meet up ends of justice, what best I can do is, I have to make them very strict direction to conclude the trial within 3 months. Because there are some materials.
Yes.
I can't intervene at the stage when the trial is on. So I will make sure that some justice has to visit you. After at least 3 decades.
My lord, 1 month is there of my retirement. 1 month is there for my retirement. I have not given a single promotion till the initiation of the process.
Give that clip. When are you going to retire?
24/2/2024.
And if these are the cases, see, you filed this petition long back, you are seeking adjournment. You should argue.
My lord, I have argued.
When retirement, date of retirement? 20?
24/2/2024.
24?
2/2024.
29.
29/2.
29. Okay.
My lord, one thing.
You have all given all judgment. You can. Thank you. Yes.
My application of section 311 is rejected. That's why I have approached Mr.
PW?
PW. IO, my lord.
IO?
Payroll 16.
Payroll 16. Here it is a maximum 300 and
No, whatever, but why it is rejected, let us see.
and so I have not put any specific question, but I had confined to that some matter fact related to the arrest of the accused is contempt construction and the illness of that accused, my lord. That is to be only that particular that's limited to that point, my lord. Should be prosecuted. So,
When was the witness examined? When was your application? 313 recorded.
At this stage of argument, prosecution completed his argument. By the time he had filed the application, recall the IO.
Very difficult.
We did test it.
so with the order of 302 minutes, that is Because higher offense, it is not a.
That's right. How many defense evidence you have? No. What are the questionnaires? Show me questionnaires.
Questionnaires have not been put, but in lots of times,
You show the questionnaires and then only you know. Not that at the final stage you want and then you reopen it.
From that point, you also said that has been rejected because specific questionnaires have not been sent.
Yes, that's right.
Correct, madam. But since he has.
You have not given the questionnaires here also.
My lord, I shall bring to lordship, my lord. The lordship will give the liberty to this petitioner, my lord.
No. You have to. I have to see the questionnaires, and you have not filed. You have not filed the
Questionnaires.
You also page
He has not filed the questionnaires.
paragraph 3, page 6. I still one page 6. You also will correct, ma'am. But paragraph 3, ma'am. Preparing the argument of the case.
Now you got a wiser at the time of preparing for argument. You left some question, therefore you want to cross-examine. What do you do? That itself is a ground for rejection. That appeal stage also you will think that, oh yes, this should have been a better place. Then again you will start a new trial. That's see the very fact that the para 3 itself is defeat your application.
Because the trial has not been ended. That way you also liberty can give him.
But I have to. You have not posed the question. And I can understand if 313 is not recorded. It is recorded. Defense evidence you have not laid. And now you want to recall IO. Why for you want to recall? Where is the question? Where is the IO statement? That also you have not filed. Better you write down. The then you have no case. Dispose. The petitioner has challenged the order dated 16/8/2023, whereby his application under section 311 CRPC for recalling PW16, the investigating officer, has been turned down. The Learned Trial Court, it is next. It is Mr. Ragada appears for the state and submits that in the present case 300 accused statement under section 313 has already been recorded. The
Prosecution also completed his argument.
Naturally, prosecution argument is over.
Argument only from the side of prosecution.
313 is recorded, and the defense has not laid any evidence. And thereafter, the argument on behalf of the prosecution, final argument on behalf of the prosecution is also over. Full stop. At this stage, the application under section 311 was moved by the accused on 10/8/2023, 10/8/2033. Perusal of the application indicates that there was no indication as to what are the proposed questions to be put to the IO. Rather, on the contrary, the accused in para 3 states as under para 3 page 6. Para 3 page 6. The Learned Trial Court, by the impugn order, rejected the application. Application on the ground that this is a ploy for delaying the prosecution. The Learned Trial Court has also recorded the fact that the petitioner has not disclosed as to why the PW16 is to be recalled for examination. Full stop. I am of the peruse the record. And I found that there is no infirmity in the order of the trial court. Therefore, no interference is called for in this petition. Hence, dismissed. Next.
22.
May I praise the Lordship? I am appearing the virtual mode, Your Lordship. In the present case, the petitioner challenges the very registration of the FIR under section 31R, 31S, 32VA of SC and ST Act. Your Lordship, in the last occasion, the Learned State Council was directed to obtain the instruction with regard to the caste certificate. That is annexed to Your Lordship. Page number 12. In the present case, Your Lordship, the petitioner belongs to SC/ST caste.
Yes.
Charge sheet, my lord, submitted under section 390,
And
294.
you might have
323.
charge sheet,
My lord, the three SCs are not there since the petitioner belongs to SC community.
it's not
Further
there.
charge sheet submitted, my lord, the
It's not there, SCSC that
294,
charges were
323.
dropped.
294,
Charge
323.
sheet, the charges were dropped.
Charge sheet already submitted.
What do you want?
Yes, Your Lordship. Permitted to withdraw, Your Lordship.
Yes. Withdraw.
Obliged.
Hmm.
May I please? Let 482 application will to quash the proceeding will on the ground of compromise between the husband and wife, my lord. Both
Where
of
is-
them are present in the
Where
court,
is he?
my lord.
Yes. Ritesh Kumar Das.
My lord, Ritesh Kumar Das is the husband.
And
My lord,
who all are the other people? In-laws.
in-laws, my lord. Father-in-law, mother-in-law, brother-in-law.
Samapika Bhoi.
Yes.
What is the terms of settlement?
My lord.
What is the terms of settlement?
My lord, it's an the case is instituted on the section 490.
No. What is what?
Both of them are, my lord, resided together, my lord. They have
They
decided,
started
my lord, their officers, my lord,
Okay.
intervene in the matter, my lord.
Okay, the petitioners are facing trial. In the what is the stage of the
My lord, now, my lord, in the meantime, charge sheet has been filed, my lord, in pendency of the
Cognizance has been
application. Cognizance has already taken on 3/10/2023, my lord. I am giving that an affidavit.
the petitioners are facing a trial pursuant to the registration of the FIR number so and so at the instance of opposite party number. Who is the opposite party number 2? Opposite party number 2. Full stop. Opposite party, sorry, the petitioner number 1 is the wife of husband of opposite party number 2. Full stop. The dispute opposite party number, since there is a marital discord, the opposite party number 2 lost the FIR against her husband and other family members of the petitioner. However, now they have settled their dispute. Settled this dispute and settled by the dispute. The opposite party number 2 has started residing with the petitioner number 1 and in his and other family members, and there is a rapprochement. There is a rapprochement. Therefore, the petitioners seeks indulgence of this court to quash the FIR. The petitioner number
1
joint affidavit. The parties have filed joint affidavit.
No, my lord, here is the affidavit filed by the opposite party number 2. That is, my lord, order taking cognizance is there, saying that
the parties have filed affidavit before this court, reiterating the aforementioned facts. The petitioner number 1 and opposite party number 2 are present in the court. They are being represented by their respective counsel. They identify their clients. They have also filed their Aadhaar card, self-attested copy of their Aadhaar card, which is taken on record. What is this? What is this?
my lord, during pendency of the 482 application, my lord, charge sheet have been filed and order taking cognizance have been taken, my lord.
During the pendency of during the pendency of the present proceeding, the police has filed the charge sheet, and by the order dated 3/10/2023, learned SDJM Raulkela क्या है? Raulkela Raulkela has also taken cognizance of the offence against the petitioner. next one. Having taken into consideration the fact that the Mr. Raghuda appears for the state and submits that since the parties have settled their dispute and the dispute is primarily a matrimonial dispute, there is no legal impediment for passing the FIR. Full stop. Next one. In order to save the marital life of the parties and to marital life of the parties, it would be appropriate that this court exercise the jurisdiction under 482 CRPC. Next one. Having taken into consideration the aforementioned factual circumstances, the FIR number so and so under section so and so and the consequential proceeding arising therefrom are satisfied.
The GR case number.
So all GR case and everything is right.
25.
March.
26.
March.
34.
Here I have a position of court assessing the legality of order dated 25/7/2023, wherein my petitioner for withdrawal of the complaint was rejected. The fact remains the present petitioner being a complainant, he has filed a complaint case. And before the court of law at JMFC Khorda, there was registered as 160 number 26/23. And thereafter, after some time, because of the good sense people between the parties, whatever it may be, the present petitioner filed application under section 257 CRPC for withdrawal of the complainant. The same was rejected by the court. My humble submission, when I am the complainant, I am the sole person who who is the instrumental for initiation of the case, or only on my statement the accused person will be put to task or will be convicted, or the prosecution will lie, my lord. When I myself has filed application by a petition under 257 CRPC, the court has the passing a rejection order or refusal to allow the same is null and void, my lord. And the specific provision under 257 CRPC is there, where
what are the offenses?
Offenses, there is mainly, as I have given a copy.
FIR was lost.
Complaint case.
156.3 you filed?
Yes. I have filed
and that says no FIR was lost. No direction was made for the registration of FIR.
No, definitely, madam. Because when I will file a complaint case, it was sent under 156 by the magistrate.
Yes.
At the moment, my lord, 257 says withdrawal of the complaint, my lord. If a complaint at any time before a final order is passed in any case under this chapter satisfies the magistrate that there are sufficient ground for permitting him to withdraw his complaint against the accused, or if there be more than one accused against all or any of them, the magistrate may permit him to withdraw the same and shall thereupon acquit the accused against whom the complaint is so withdrawn. But here, my lord, the question of a complaint doesn't arise as because the moment it has been sent to the police, my lord, it became the registered PS case, my lord.
That's what I'm asking, whether FIR is registered or not.
My lord, it has been registered. My humble submission, because the statute itself is the final order. Final order means, my lord, after the investigation will be completed, a charge sheet will be submitted, and thereafter the court will take cognizance. That is the final order. That is my humble submission. So unless until that stage, because here
what was the allegation made by you?
Allegation, madam, see page 8, the complaint case there when I have said
436 is there also. 436 is there. 436 travel assistance.
That they enter into my house.
395 also there.
They enter into my house, ransack my properties, and these are the allegations. And because of the previous dispute, admittedly, I have made 37 persons are the accused persons in the complaint case.
37?
Again, let me see.
All are 37 are there.
I can say. That's why I have come, my lord. And as the statute says, my lord, unless until final order be passed, the complainant has a right to withdraw, my lord.
No.
Here no final order has been passed, my lord.
Apart from 257, the Bhajanlal also will come. Because see, if you put to trial, if the complainant will not support the case, why?
Exactly, my lord, exactly, my lord, exactly.
That is true, my lord, but in fact,
257.
I am, because
I'm exercising 482. Tell me, if you put this 37 people to trial, if the complainant doesn't want to proceed, he will positively not
my
support
lord,
your case.
the very
What will you
section,
do?
my lord, the very section, my lord, it is a complaint case, my lord.
It's a complaint case.
That has been sent to the police, my lord.
Even
FIR has already been registered
Even if it is FIR.
and became the GR case, my lord. It is the state, my lord. The state can withdraw the case, my lord. It is up to the PP. He prays to PP. PP
I
send to
am
the
only something else.
my lord.
Can I not quasi?
Yes, yes, your lord. For it, yourself.
If the exercising futility,
My lord, yourself.
why? That is the one of the parameters in Bhajan.
Your lordship can quasi.
Bhajan law. Compromise, it is beyond compromise. One step higher than
I had my
your lordship has it right. For it, can exercise.
Ligo. The petitioners.
No, petitioner, one person, complainant. Who is the I get it. Other type of man.
Yes. The petitioner being the complainant.
I get it.
1cc case. Filed like 1cc case.
26
number
or 2020?
being number so and so.
25.
So and so. Big number so and so. But I am still saying you this kind of petition one should not entertain.
No, my lord, I have your my lord.
No, not on that. You have not filed anything except the order. What is the complaint? What is allegation? Why? Where is the FIR? What is the FIR number? Nothing is filed.
Now the already GR case, my lord, must have been registered.
If you don't get the GR case, where from I get
that will meet the purpose because I am praying for 1cc.
Do you have that anything on record? So
I have said so.
Take on record.
My lord, better, my lord, friend will
one
day after tomorrow.
you have not filed
anything.
No, I have said so. It has been sent under 150/3 and resulted F.
That's right, but where is that FIR number? At least facts has to be recorded. Otherwise, they will challenge it and again.
That's why 210. That's why 210 is there. This one will kind enough to quash this.
I'm ready to quash it. I'm
saying. Yes, man, said it will meet the purpose because the master because the initiation is this.
I understand it. I will quash it, but I will have to record what is the fact transpired. Otherwise, what will happen is the state will go and
take it on Friday.
Friday. You come at least if you can't file.
I will file.
Pass on to me so that I'll take on.
I will file.
Okay.
That's only my lord.
First 5 matter you list it.
My lord.
First 5. We'll do it. Let it be on Friday. Or 29 we'll do it.
My lord will take it Friday. Or 22nd.
That I'm not available. 29.
This one.
29 first case in 29 to do it. File all these things so that at least I need to record these things. Otherwise it will be in.
My lord also indicate that in the meantime it has been recorded and both the GR and this will quash that will be.
I'll quash that also. Yes.
35.
May I please, Lord? 35 and 36. Case under case on the ground of compromise, both the parties can be.
What is the offense?
506 is an unvaluable offense along with other valuable offense at 341, 294, 3.
What is the allegation? Why 2 petitions?
Minus?
Why 35 and 36?
But 2 FIR, case and counter case. And
Santosh Kumar Malik
both are present before this honorable court.
And Satyanarayana Panda is in the other cross case.
Yes, sir. Okay. Both are present before this honorable court. And allegations.
What is the allegation in the other FIR?
Both of Rastare Gola.
Same offense.
Yes, sir. Same allegations, but have been settled. Both are present before this honorable court.
Joint affidavit will file.
The affidavit they have filed, Lordship.
Affidavit, separate.
Yes, separate affidavit before the commissioner they have filed.
Yes, Mr. Maharaj.
Affidavit का है?
Yeah.
The lordship is having affidavit. Yes.
Copy दिया है.
Yes.
ठीक है.
आधार कार्ड टी दे दे.
दीदा का मैटर में गुट्टे ऑर्डर कर. कॉमन ऑर्डर.
Original आधार कार्ड.
केस क्रॉस केस अच्छी तो नो.
गुट्टे ऑर्डर है ले. There are cross case filed by the petitioner, the petitioner in the first case is suffering the trial, na? Trial chal raha hai ki nahi?
No, my lord. The questioning of affair, that is not
Sub-
submitted.
That's it.
No, my lord.
At the instance of the opposite party number 2, दुईटा अलग अलग लिख दिया confusion हो. Opposite party number opposite party number 2, Satyanarayan Panda.
Yes.
Satyanarayan Panda. FIR number
Malgodam PS case number.
Malgodan case number 163.
My lord.
Yes.
2022.
2023.
Yes. Is registered against the petitioner.
Yes.
क्या नाम है? संतोष कुमार महालिक.
संतोष कुमार
महालिक. Next one. A cross case at the instance of Santosh Kumar Mahalik is also filed against Satyanarayan Panda, who is the petitioner in the cross case, being FIR number
162.
Malgodam PS case number 162 by 2023.
In both the both the cases, and both the cases are arising out of the same incident, and the offences are also same, namely under section 341, 294, 323, 506, and 34. Full stop. The petitioner in both the cases, those who are opposite parties in the cases against each other,
yes,
are present before this court.
Yes.
They are full stop. They are represented by their respective counsels. And are identified by them. They have filed the self-attested copies of their Aadhaar card to establish their identity.
Yes.
Full stop. They have also filed separate affidavit.
Yes.
Separate affidavit reiterating their stand that they have settled their disputes among themselves so as to buy peace and they become friends.
Yes.
Mr. Mahajan, Mr. Maharaja, always I say Mahajan because Mr. Maharaja, appearing for the state, submits that these are the cross cases against each other filed by the petitioners, and since they have settled their dispute, so there is no legal impediment in quashing the same. Next one. Having taken into consideration the fact that the parties have settled their dispute and they filed cross cases against each other, I'm of the opinion that this is the fit case where the inherent jurisdiction of this court could be exercised, and accordingly the FIR number so both the cases,
both the cases,
and consequential proceeding arising therefrom are set aside.
Bas.
Oblige.
Both the cases. Yes.
38, 37.
The petitioner pays for quashing of criminal proceeding on the ground that the petitioner and victim married to each other and they have blessed with a child.
Settled with
yes.
What are the offenses?
Date of birth certificate is at Annex 3, page 13.
What are the offenses?
Offense initially 363 registered, FIR registered under section 363.
What was your age by the time?
By that time 17, man.
Subsequently
17.
Pokso added.
This petition under 482 for quashing of proceeding. However, the petitioner is now willing to surrender before the learned lower court below only prayer is his bail application may be disposed of on the same day on surrendering.
You surrender, it will be done. Why should you appeal? The petitioner has filed the present petition seeking quashing of the NBW has been issued.
Yes, my lord.
By which order?
Order Annexure 1, order dated 8/10/2022.
The petitioner is facing trial. Trial? You are facing trial?
No, my lord. Trial not yet.
39, my lord.
Huh?
39. 39. Warrant has been issued against him.
No, whether he was on bail or what?
No, warrant has been issued.
Trial court issue warrant.
Yes, yes.
Trial court,
Yes.
not on bail. He is
Okay.
willing to surrender before.
The petitioner is seeking quashing of the entire criminal proceeding initiated against him by the investigating agency, by the police in this petition. The perusal of the record indicates that on 28/10/2022, NBW against him has been issued by the ADJ from Special Court. The allegation against him is under section under section so and so
341, 323, 294,
so and so
354.
page 11. It appears that the petitioner has been absconding from the case. That is the reason the NBW has been issued.
Yes.
The counsel for the petitioner submits that he would be. How much time will you take to surrender?
3 weeks, madam.
3 weeks.
The first anticipatory bail order ta comply karna thi. Again, this applies.
I know.
State or direction haitila surrender karibo.
Simply, I will say that he takes 3 weeks time to surrender before the court. Surrender before the court below. And take recourse available to him under law.
Yes.
Disposed.
This person.
Yes.
Kindly, bail application may be disposed of on the same day.
I have passed the order by what generally I pass. You avail the report.
FIR last by the OP
Yes.
number 2, the present petitioners have been implicated in an
Kete?
operation. 40.
40 copy dio.
40? 40. Copy.
Copy I have already. There is a matter of
Already given now.
File is not fit. For that reason, I am not sure. But there was a settlement between the petitioners and the opposite party number 2.
What is the offense?
Offense count.
509, 354C, 323, 294, 506, 34 of the Indian Penal Code, Revenue Section
19.
Yes.
30th October 2019. What is the stage of trial?
Set the code. Abhi to asini.
What is the stage of trial? 20 witnesses are examined.
Yes, Lordship. Sir, final stage of.
So 313 recorded. Huh?
Your Lordship may kindly see page 17. Case date is posted to 15/7/2023 for argument.
At this stage, you want everything. This order was passed on when? July. 6 July.
6/7/2023.
Who are these?
तबरे एटा रिकॉल हेतिला एग्जामिन कलेनी एटा रिकॉल हेतिला
Sorry, recall it.
हां सेटा एग्जामिन कलेनी
Where is that?
that is your Lordship may kindly see that third para started from objection. I'm read one portion I'm reading. The last witness was examined on 17/9/2019, whereafter the incredible circumstances were read over to the accused person on 21/9/2021. Thereafter, on 30/10/2019, prosecution filed a petition under section 311 of a CRPC and sought for examination of the doctor, which was allowed. Since then, the case was lingering for the examination of doctor. Finally, on 8/6/2023, the case of the prosecution was closed by the court as it failed to examine the doctor during that.
Is a doctor.
Yes.
without calling
3
the
years.
doctor? Huh? You have no clue. You have no clue, it seems.
ସେ କଣ instruction ଆଣନ୍ତୁ ବରଂ argument ପାଇଁ ରହିଥିଲା କଣ ହେଲା କଣ ନାହିଁ
You seek instruction, what is the stage?
15/7/2023 ମାନେ
Second week, second
ବହୁତ
week.
ଡେରି ହେଇଗଲା ନା ଆପଣ instruction ଆଣନ୍ତୁ ଆଉ ଗୋଟେ ଡେଟ୍ ହବ
Second week of February.
Next month.
ହଁ ହଁ
Next
2nd
month,
February
okay. Second week of 19, 20. Next, 45.
44.
44. 44.
On behalf of Mr. Pradhan, I may be permitted to place the matter.
Huh?
On behalf of Mr. Pradhan, madam, I may be permitted to place the matter. On
I'm
behalf
not
of,
able to follow you.
on behalf of Mr. Pradhan, I may be permitted to place the matter
Yes,
because
sir.
I have no power in this case.
I know.
Yeah, my lord, petitioner filed, my lord, for quashing of the proceeding, my lord, on the ground that, my lord, that no materials are available to implicate the present petitioner in this case, my lord. But now, my lord, I got instruction that in the meantime, matter has been amicably settled between the parties. If your lordship will issue notice to the OP number 2, because I made the party to OP number 2 with an informer, my lord. If the notice will issue and she will appear, my lord, then
Simply I will issue notice.
My lord.
The counsel for the petitioner submits that there is a settlement between the parties. Issue notice to the opposite party.
Party number 2.
OP number 2, my lord.
OP number 2. Mr. Maharaj appears for waives notice. Next. They
Give
will, give it in February 2nd week. Second week. Second week or third week, whatever suits you. Whatever suits you. 20th.
The matter was posted to 24 of this month, my lord. And
You seek adjournment. I am issuing notice.
if your lordship will pass that order, my
See,
lord, if
what
I will
happens
file an
is once I
application.
keep adjournment, then you next time you will never come. Because interim order is there, then it
No,
goes on and on.
No,
and
no.
on.
Case of Cuttack.
You can seek at least the trial court knows settlement has taken place, then you let it.
Case is in Cuttack, my lord.
No, you
If
can-
your lordship will fix before 24, then
24 of the February.
this month.
huh?
This month.
No, this month is not possible. When the petition was filed? When the petition was filed?
Petition was filed on, my lord, 6/11.
And today it is
Mine.
listed, then you should have.
Only your lordship may say,
No,
if I will file an
you
application.
seek adjournment.
Pardon, my lord?
The matter is listed before, counsel for the petition submits that matter is listed before court, maybe trial court on 24th of this month, 24th January so and so, and he would be praying for an adjournment.
My lord.
45.
Lordship may kindly pass over this matter. Is on his day.
Who?
Learning council.
You argue.
No,
Second hour, 3 o'clock, what pass over?
Lordship on his order, day gets-
You argue whatever you know.
Lordship,
You where is the file you have, na? You argue and argue, what is this case? What is the prayer? Read the prayer at least. Cognizance order. What is the offense?
498 देखिए ना
498A.
हाँ जे divorce person mutual divorce allowed.
Allowed.
Yes, page 28.
So notice कर दो.
Notice कर दो.
Issue notice to the opposite party number 2, opposite party number 1. Returnable within 1 week. 1 week. What is it?
OP number
1.
OP number 1.
9th February. Notice.
Obligation.
See why and if you senior would have come, the same thing would have. You would done it. Yes.
46.
May I please, your lordship?
Yes.
The petitioners has post.
Huh?
Offense under section 373, 417, 120B, 25 of interested migrant worker, regulation of employment and condition of service act.
Yes. What do you want?
I want the class of
Quashing.
proceeding. The lordship last occasion directed to produce the labor license of the petitioner. And in the memo, the petitioner got the labor license.
ये तो
State of Telangana to engage 100 numbers of
Mr. Maharaj is saying something. Yes.
ସେ କୌଣସି ଇନଷ୍ଟ୍ରକ୍ସନ ଦିଆ ହେଇନଥିଲା କେବଳ କେସ୍ ସେମାନେ ପ୍ରେୟାର କରିଥିଲେ ଆର୍ଜନ ପାଇଁ ଏ ଦିଟା ଆଣ୍ଟିସିପେଟରୀ ବେଲ୍ ଫାଇଲ ହେଇଥିଲା से दीटा order भी comply करना थी. Again, this 482 application has been filed.
Where is the
I have
order of
annexed
the?
the anticipatory bill, your lordship can see annex to page 33. The first hour and second order the page 34.
Comply तो करेनी गुटे 2021 ने गुटे order हला ताको comply करेनी. Then 2023 order हला ताको comply करेनी.
No, we have not surrendered.
Huh?
Not surrendered.
Why?
And court has honorable court has observed that this petitioner has misrepresented the court by not mentioning the previous bail application in BLPL number 9568 of 2023. And the purport hochi a BLPL 12498.
What is this you are doing? You disclose everything and file.
Only disclosed whether he has.
No, in this petition, let us see.
नहीं ये petition समान देचुन दीटांको mention
Why are you not surrendering? If there is an order at your instance, it should be complied.
Say order by this honorable court, this should be complied.
You thought that you will file this quashing and will get a no course action.
No, my lord.
Then what do you want? How the case is not made out against you?
Because I have the license to supply the migrant worker of about 100 numbers. So you can see the memo I have filed today. The total number of migrant workers which has been rescued by the FIR is 97. On that ground that I have not forcefully transporting the migrant worker to other states. I have the license and
you may be having license, but on the garb of this license, you can't take people those who are unwilling.
That is the statement your lordship can turn to page 16.
Page 16.
Yes, page 16. That is the statement of the victim.
Then unwilling.
So माने specific कोई चंती जे बलांगीर लेबर सरदार अब्दुल सजीद खां alias पप्पू alias कप्पू खां मोते हैदराबाद रे इटा तैयारी कले अधिका पैसा मिलिबो कही आमको ठकी अधिका पैसा रोजगार लालसा देखाई निज फायदा पाई षडयंत्र करी किछि पैसा देई गंतव्य स्थल रे पहुंचले अधिक पैसा देबु बोली कही कंटाबांजी रेलवे स्टेशन रु पूरी शिरडी जाई शिरडी साई एक्सप्रेस रे जीवा पाई कहला मु ता कथा रे लोभ रे पड़ी सखाळु मो स्त्री दुलारी सतनामी ओ चारि छुआ सहित कंटाबाजी स्पेशल को आसिली ओ सेठारे आहुरी मो परी अन्य ग्रामर लोक माने मध्य उपस्थित थिले मु सेमानकु पचारि बारे जानिली जे सेमाने मध्य लेबर सरदार अब्दुल सजीद खां alias पप्पू alias कप्पू खां किछि पैसा प्रलोभन देखाई इटा तैयारी करिया पई लाइसेंस अछि एगुडा सब देखै कि नै गले ताकु देलेनी पैसा आगो.
You have a license, therefore you can take people like this. There are statements, you have to face the trial. Where is the question of no question of quashing it.
Your lordship can adjourn matter at least 1 week. I'll produce whether they have surrendered or not before the court bill as per the order of anticipatory bill.
Better you withdraw it and take recourse to already. Don't invite a problem for your clients.
Your lordship, I don't have instruction whether he has surrendered or not. Your lordship can adjourn and take instruction.
1st February.
Adjourn.
Learned counsel for the petitioner submits that he would be seeking instruction regarding instruction from his client as to whether they have surrendered to the jurisdiction of the court below or not. As per the bail condition, as per the order of the court, order of the coordinate bench. While disposing of his bail application under 438 CR.
He has not surrendered because that was a conditional order that if he surrenders, he will move for the bail. He has not surrendered. I am seeking quashment of the entire proceeding because I have got a license.
But the statements are such that the garb of license you can't take somebody without their this thing.
No, money was paid to them, and I have got a valid
pay
license.
money whatever. But
I give it to your lordship because
see, this is not a case for quashing. You want to withdraw?
No, your lordship may pass on this because when withdraw is difficult. I'll face another problem in bar terms. Why should I take that trouble, my lord?
But anyway, I have kept it for 1st of February, you come.
My lord.
On record, bring there. Yes.
47.
Yes.
My lord, can it be on 30th?
30th, okay. No
30th.
30th. Okay, no problem. 30th.
But in this case, the concerned ISA just transfer 4 days before. So can I, my lord, take one more turn? I will take it.
You tell me which date.
Yes.
Which date?
Any date will also may kindly take off 31st.
No, first week.
First week or just first.
2nd February.
Yes, 2nd.
48.
48.
Rising out of the complaint case, the present petitioners are implicated in an offense section 498 to 420, 323, 294, 506, 379, 34 of the Indian Penal Code. Petitioner number 1 is the son-in-law of the complainant, oblique the informant. And in the meantime, the matter has been settled and the daughter of the informant is residing with the petitioners.
The petition, the present petition is filed seeking quashing of the FIR number so and so. The learned counsel for the petitioner submits that he is Sangram Manti.
Mal.
Is the
son-in-law
of
the complainant.
Petitioner number 1 is the son-in-law of the opposite party number 2. Opposite party number 2. They are staying together, huh?
The daughter of
the matrimonial dispute is settled between the parties, and the daughter of the opposite party number 2 started residing with the petitioner number 1. Petitioner number 1. Therefore, he seeks indictment of this court to quash the criminal prosecution launched against the petitioners. Issue notice to the opposite party number 2. The parties may file their joint affidavit before this court by next date of hearing and appear before this court. 12th February.
Stay of further proceeding.
In view of the aforementioned facts and circumstances, in view of the statement made by the counsel for the petitioner that the parties have settled their dispute, the further proceeding in the case so and so it's a stay. In the next date of hearing.
49.
In this case, the annexed 4 is the improved manners at page 21, the passed by the JMFC ERSOMA matters. In exercising power, manners, the discretionary power under section 143A of the NI Act manners, he has awarded interim compensation of 20% of the check amount manners, which is the extremely higher side of the interim compensation. The statute says, my lords, it is not exceeding 20% manners. It may be 1% or it may be 20%. But the learned trial court, my lord, choosing the higher side without assigning any reason how we are choosing the higher side of the
less than 20%.
Manners. No, not exceeding. 20%, awarded 20%.
20% he can do it, then it discretion.
Reason must be,
Where is that provision? Reason should be given.
You also kind of grant the judgment cited.
No, provision show me.
43.
Oh. Provision. 43A
manners.
43A.
The power to direct interim compensation.
1 minute, 43A. Yes.
Notwithstanding anything contained in the Code of Criminal Procedure, the court trying an offense.
1 minute. This is the old one. The new one. Read it. I don't have this. Yes. Notwithstanding anything.
The court trying an offense under section 138
may order the drawer of the check to pay interim compensation to the complainant. A. In a summary trial or a summons case where he pleads not guilty to the accusation made in the complaint.
Not pleading guilty. Yes.
That is more vital.
Yes.
In any other cases, upon framing of charge.
Yes.
2 minutes. The interim compensation under subsection 1 shall not exceed 20% of the amount of the check.
Reasoning कहाँ लिखा है? Statute. Statute is silent about it. Within that 20%, they can do it.
He must have given the reason.
Why? Where is it? Statute doesn't say reasoning. What is the check amount?
Check amount, manner says 5,50,000.
Do you have any judgment to show that reasoning has to be given?
Yes, ma'am. I have given. I have cited his judgment manners in the case of manners.
Show me.
Reported in 2019-76 was here.
Give me a copy.
It is one case, one copy of manners.
Page
1. That is.
This is for your consumption only, not for the judges, not for the. You are citing some judgment, at least you should give a copy. Tomorrow, I can't take time like this. First of all, prima facie, I am not inclined. Read out the relevant portion. Read out the relevant.
My lord, I am for the opposite party. My lord, felt that they had assigning any reason, the lord could pass the order. My lord, kindly see the page 27, para 9. She already given the reason.
27.
27, para 9 of the criminal mistake.
Yes.
Thus, from the above discussion, it is apparent that the conduct of the accused is a relevant factor. While considering an application under section 143A of NAS, on perusal of the record, it is found that the application for interim compensation was filed by the Lord Council for the complainant dated 26/4/22.
The copy of the same is
the
same day. Then the accused is
Since then, the accused remained absent on several days and filed his objection.
Reason.
This is the
perfect reasoning. Perfect reasoning.
My lord.
Perfect reasoning. देखो, 1 minute. हो गया. The petitioner has filed the petitioner has filed.
That is the conduct of the petition.
Petitioner has filed the present petition seeking passing of order dated 16/8/2020.
That is not a one point. Another point is also. That is another point, madam. There is regarding procedural defect, madam. Why even this? That is non-obtaining clause matters. That is section 145 of the Act matters that have not been complied. Because the complainant filed matters, the evidence affidavit. There is no given the chance to cross-examine them. There is no cause of action.
But that is not your prayer. Your prayer is for passing of 16/8/22 order. That order is see the prayer.
That is there, ma'am.
That is only there.
That is the cause of action. Rather to find the 143A of the.
No, that is not the petition here. That is anyway. Which provision you are reading? 145.
This is the stage of
Not
the
understanding
initial
anything
stage.
contained in the Code of Criminal Procedure. The evidence of the complainant may be given by him on affidavit and may subject to all the. What do you want here? He is not given affidavit. Then
Affidavit given.
Then
the Lord given the chance to cross-examine. Given the chance.
1 minute, I understand what. Yes.
There is no given chance to cross-examine.
In pre-summoning evidence, no chance is required. In the post-summoning only, you will get the chance. This is minimum. He has filed affidavit in pre-summoning, and in the cross-examination, you will get the chance after the summoning order is passed and notice is preempted.
43A subclause A says, my lord, in summary trial, my lord, then B says, upon framing of charge, A said, my lords, where he pleads not guilty of the offense made in the complaint was. But that here, my lords, what happened? The case posted, my lords, the case posted, my lords, 27/1/2020 for appearance of the accused minors. On that day, the petitioner made prayer under section 205 of the CRPC for dispensing with his personal appearance minors. From that day, the accused not appear before the court. Where is the charge framed? But in the learned court says,
in this petition, you want to bring everything under the sun. What is the prayer you just read?
Thereafter, the cause of action.
What is the prayer you read in your petition? Read your prayer.
The prayer for quashing of the order, man.
Then you are bringing every possible thing here.
The cause of action.
Oh, maybe 1,000 cause, but I have to go by the prayer you made in the petition. I can understand if quash entire proceeding, I can understand. You say that quash the order dated 16/8/2022, by which your application under 143 capital A is dismissed, saying that the precondition of compensation is 20% is higher side. Court gave a reasoning saying that you have been absent, and the statute says that it can be up till 20%. 20% is
my humble prayer, my lords, 43A has not been complied by the learned trial court, my lords. The 43A subclause A says that is the accused pleaded no guilty.
Therefore, compensation.
I'm not pleaded, my lords.
Obviously, therefore, compensation.
No, my lords. When the accused pleaded no guilty, there was cause of action arose for the compensation, my lords.
Then
interim compensation.
Yes, that is what the court has done.
That is,
you have not pleaded guilty. You wanted to face the trial.
No.
So therefore, the compensation.
There is no cause of action arose to the accused to plead no guilty, because 205 after 205 is not present before the court. Advocate is present. When the accused will present before the court, charge was framed. Will be framed.
If you don't go to court, then how charge will be framed?
So there is a condition precedent. When the charge is framed, the accused must be present before the court.
So you present in the court. Argue all these things in charge.
Before that, he has interim compensation.
No, compensation can be done. Just see 143A. 143 KP.
Yes, ma'am. In a summary trial or a summary case where he pleads not guilty to the accusation, made the complainant.
Yes, you plead not guilty. Are you pleading guilty? Then conviction will be recorded and this thing. Are you saying that? You want to face the trial? So therefore you say that you
cause of action arranged for to face the trial. Court has not asked to say, man. When the charge was framed, that is that on that point of time the court can say
no.
Yes,
at the time of taking cognizance, if you plead guilty cognizance, then you lose.
At the addition stage balance cognizance are taken. Thereafter,
you want to contest, then you are not pleading guilty. If you want to not contest, then you plead guilty. What is your case? Are you going to plead guilty or you are not pleading guilty?
No, not pleading guilty.
Then, therefore, you are contesting 205. Also, you moved. Therefore, your intention is to contest it.
205 petition has already been moved, and that was allowed by in favor of the accused minors dispensing with the personal appearance. Thereafter, the court should take a charge against the petition, but that is not there.
Kindly see the petition. Para 4 of the petition. It is specifically submitted here that the complaint opposite party after filing of the complaint case a cognizance of the offense was taken and summons to issue to the accused petitioner who accused because of court.
I know he is not pleaded guilty.
Already he has pleaded here.
The petitioner challenged the order dated 16/8/2022, by which the trial court rejected the application of the petitioner. Application of the petition. I read it. Everything I read. By which the application of the petitioner, application of the complainant under section 143A of NI Act was allowed, and the accused, oblique the petitioner, directed to pay 20% of the check amount as an interim compensation. Also, the Land Counsel for the petitioner submits that the award of the direction of the trial court to deposit 20% of compensation is is higher side, and higher side. Therefore, the trial court ought to have given reasoning for the same. The reasoning for the same. I have perused the which paragraph you read? I have perused the impugn order. Which paragraph you read? I perused the impugn order. The trial court, while allowing the application of the complainant, in para 9 of its order, records as under para 9, page whatever 27, yeah, is 27, page 27. So then counsel for the petitioner also submits that there are many flaw in the prosecution of the complaint case, as procedural requirement has not been followed. Procedural requirement has not been followed. So insofar as this submission is concerned, the petitioner is at liberty to raise all his grievances at the appropriate stage of the trial. However, since the instant case is in the instant case, the sole prayer of the petitioner is regarding the washing of the order dated 16/8/2022. 22. I am of the view that I find there is no infirmity in the order, in the state order. Therefore, therefore the petition deserves no merit. Hence, the petition is dismissed. However, the petitioner is at liberty to raise all other objections before the trial court at the appropriate stage of the trial. Yes. Other points which you have raised, maybe valid point, you raise those things there. I have given that liberty. Now I have done it. Now don't. You want me to allow? You want me to allow? No, that is the he has challenged. I dismiss. That's finished. Next. Item 50. In his petition, you want relief. Yes. 50.
I am for the OP. State has filed this petition, my lord.
State has filed. Yes.
State has lost in 2 forums.
Yes.
So application, my lord, where the 457 application is filed by the opposite party, the release of his vehicle Mahindra Bolero and Maxi truck, 2 vehicles, that has been released in his favor. That has been challenged by the state before the revisional forum, where that order has been stayed for a certain period, and thereafter the order was directed confirm the order passed by the learned SDJ. That order is challenge before your lordship.
Oh, yes.
Why?
What is the infirmity?
The ground is that. The ground is that under section 56(3) of Forest Act, a new section has been inserted where during pendency of the confiscation proceeding, it is the only confiscation officer can release, no magistrate can release the vehicle. That is the specific provision you also can
Let us
see 56
Forest Act.
Forest Act.
Read.
Ma'am,
50?
56.
Okay.
Section 56.
Are you ready? Are you ready? He's arguing.
My lord, let it come next week, my lord. I also have to verify the section 57, 56 of the Forest Act. I have not bring the book, my lord.
He's arguing quietly, and thereafter you waste the time. Thereafter you say adjournment. Adjourn it. He's not
Next
ready.
week, my lord.
You are not ready. You from your demeanor only, I could understand that you are not ready. Whether by the 56, at least
56.
for his benefit, read it out.
Yes, yes.
So that he'll seek instruction next time. 56. Yes. Disposal on the conclusion of trial for the forest offences and for procedural.
Seizure of property liable to confiscation.
Oh,
56.
huh?
56.
Indian Forest Act.
Odisha Forest Manual. Odisha Forest Act.
Not Central Act, huh?
No.
Okay, read it.
Odisha Forest Act.
Odisha Forest.
Section 56. Seizure of property liable to confiscation. Section subsection is, my lord, I am reading. Any person agreed by any order passed by under subsection 2A or subsection 2D may within 30 days from the date of commencement of such order appeal to the district judge having jurisdiction over the area in which the property has been seized, and the district judge shall, after giving an opportunity to the parties to be heard, pass such order as he may think fit. And
So eventually district judge will pass the order.
Yes, right. I'm going to that. And the district judge so pass shall be final. The property seized under this section, subsection 3. The property seized under this section shall be kept in the custody of a forest officer or with any third party until the compensation for compounding the offence is paid or until an order of the magistrate directing the disposal of the received, provided that the seized property shall not be released during pendency of the confiscation proceeding or trial, even on the application of the owner of the property for such release.
Clause 3.
Very important.
What was the condition for release?
Photographs release.
No. Indemnity, something.
Indemnity bond.
Security.
Yes.
What is that?
That is there.
Valuation was done. Valuation of the vehicle is done.
My lord?
Valuation of the vehicle was done. And the furnish the cash security.
Cash security no, the condition lekha hoichi. I'm reading the conditions of the.
You just read it out and come.
Yes.
Indemnity bond of 1 lakh is
yes
for to be furnished, my lord.
For one vehicle. And both vehicles.
Two vehicles.
For one.
He's not sure about anything.
No.
You read it and come.
My lord.
Next.
51. Next week.
Operation, my lord, one miscase is filed for operation of the order. Stay operation.
Already not released.
No,
not released.
Oh, short date, I'm giving that.
Next week. I will
Put it in the first week. First week. Prepare and come. Don't waste time. By this time, we would have disposed it.
Yes.
Coming to High Court, you should ready. How can you forget? Going to examination without pen. Okay. Come, no. Huh? First or second. 12th February. Yes.
I mean, pardon, my lord.
Item till then you lost him.
You
operation order ta release he gala tali a application filing ta process he.
आपण केबे फाइल करथिले एटा
हम फाइल कोन बहुत दिन ले फाइल कर
Not pending actually no interim order. I don't know. Once interim order is given, it will never be heard. I know.
State is a party. State is
All right, but state you can't.
we
don't
can
see-
take action, man, because we have filed this.
But you also stall it also. You have that power of stalling everything. Then next.
I mean, pardon, my lord, item 51, my lord, that for next week, my lord, and senior advocate, Mr. Ashok
51.
Kumar Mohanty will
Yeah.
argue, my lord.
Lordship observed that once interim order is in operation means case will never be heard. This is a case of that type.
Oh, 51. You have got the interim order.
Yes, my lord.
Okay, so I will vacate then.
They have got.
If that is the
Senior,
case.
senior advocate, Mr. Ashok Kumar Mohanty will argue, my lord. So that's why, my lord, I prefer next week, any day next week.
See, you
Any
got
day next week.
adjournment last time.
No, my lord.
Yes,
Last day I have not
yes.
taken time, my lord.
Yes.
My learned senior associate, my lord, have taken time, my lord. Last occasion, my lord.
No, no,
pardon, I mean,
Senior, my lord.
You, on 10th of July
Well-
also you have done the same thing.
Yes.
No,
And no will not make no always. You have to see the
on that day,
proceeding.
my lord, I have
Well,
seen
Lord,
the counter, my lord.
I mean, VC Malad dam for opposite part number 3 bank. Malad,
Yes.
incidentally, the borrower has cleared the whole amount. So we are waiting for the orders, as your lordship directs. So we are supposed to give the NOC to
What
the
is the
borrower.
problem today?
My lord, senior advocate, my lord, Mr. Ashok Kumar Mohanty will argue, my lord.
And
That's
generally
why-
for
has been
with due
engaged by the
respect to the
petitioner, my lord.
again a big senior here,
Petitioner
and
engaged
on the ground of senior never adjournment is sought. You can have alternate arrangements.
one day, my lord, next Friday, my lord. Let it come
I'll
Friday.
put it on 29th.
Published.
All right.
Published.
29th. Sir, you have any problems?
I pay short date be fixed because a tractor.
Short date means that only 19th I can fix. And next week I am not there. So therefore 29th is the first availability.
19,000 आवश्यक है 19,000.
नहीं ସେଇଦିନ half court ଆପଣ ବି ତ busy ରହିବେ.
ଆସୁ ନ ପଡ଼ିଲେ ସେ 19,000 ତ 29 ମୋର ଟିକେ ଅସୁବିଧା ଅଛି because on fast way.
19,000.
24th, my lord, let 20 next week.
No, no, 19th,
Yes,
19th, 19th. 19th.
Okay.
But you will be busy on that day because of last day. And there are, I think,
Reference.
of the full
Reference.
reference is there. I think 19 there are very blink chance. There is division bench also. I have. 30th कर देवा 30th.
No, sir.
30th we will do 30th or 31st.
After 30th man, after 30th.
31st करिया.
30th.
First करिया. First or second.
First second one meeting है छोटा. High Court meeting है meeting.
Let us 5th then. 5th is
Yes.
best. 5th is best.
Yes.
Once it is listed, then we will hear it and finish it up.
Yes. Direct that before that, any written submissions may be extended.
At the on behalf of the petitioner, a prayer for adjournment is sought, which is being opposed by the opposite parties. This matter is adjourned to 5th 5th February. It is made clear that no further adjournment will be given this matter. In the meantime, the parties may place their written submissions.
Interim order.
If you don't come, give written submission, I'll dismiss. Okay. Interim order. Interim order. Yes.
Question of cognizance in view of compromise.
Compromise.
Yes.
Offense.
I am for the opposite party number 2. The
Offense.
Informal man.
Writing.
Yes.
That is also directed the state to take instruction from the concerned IAC whether the matter has been settled with the parties or not. I have received the instruction. It has been stated that the accused persons voluntarily compromise the matter through village gentry without any criminal intimidation or force. They are belongs from same area and maintaining peaceful life, forgetting past events. The character antecedent of Sri Ramesh Chandra Swami is not noted below. And that the character only one antecedent is there. So far Ramesh Chandra Swami is concerned. So but the second case is concerned that is compromised and also same instruction and only no cases is pending against this petition.
There are two cases.
In two cases.
Which one?
The next one.
53 and 54.
52 and 53.
Cross cases.
Yes.
Cross cases.
It appears to be Rangpur,
No.
15, Rangpur 5.
1 day, 2 occurrence only.
That are likely to be cross.
तो आपण कोण कहउचंती करदेबा
एथरे सब तो आसी गेला
करदेबा
काय unnecessarily
टाइम खराब नहीं कर
ସେମାନେ appear କରିଥିଲେ, they have also appeared before this one.
कण देखो केबे बेरितिले
सेटा होची डेट होची 18/9/2023. Yes, 18/9.
File their joint affidavit.
हां लिखो
Both parties also appear
Okay.
before this.
The ये फर्स्ट मैटर है 52 रे ना दिस इज 3171 ना हां 3171 this matter was taken up earlier by the coordinate bench and has been pleased to pass the following order. Order dated 18/9/2023. When the matter was called up on 3/10/2023, the council appearing for the state sought time to seek instruction from IIC Gangapur police station.
IIC
Kanpur.
Yes.
Gangapur police station. Police station. As per the earlier
Gangapur.
as per the earlier Mr. Mr. Maharaj is appearing for the state and submits that he has obtained instruction from the IIC which is placed on record.
Yes.
And
I'm filing this copy.
File placed on record. As per the instruction of the IIC, he submits that line report IIC he submits that the parties have indeed settled the disputes amongst themselves and to maintain peace and tranquility in the area of the peace and tranquility in the area. The parties have decided to terminate the criminal case pending before criminal case initiated against the petitioners. Next problem. Take taking into consideration the attending facts and circumstances of the present case and the report filed by the IIC so the FIR number so and consequently writing there of terms first. Second direct video. It was 3172. 3172 share लिख दो आए भी थिला ना तार भी सेम थिला same order same
PSA only difference number is different.
The number is same order same order होती same order उतार की same ठीक है done 52 53 को ला
54.
May it pleases my lords. The petitioner seeks the indulgence of this lordship of this honorable court for quashing of the entire proceeding.
My lord, before my lord and friend starts, I am appearing on the OP number 2 informant.
What do you want?
My lord, matter has been settled, my lord.
What is the offense?
Offense under section 376 clause 2 subclause N of IPC, my lords, and section 6 of the POCSO Act, my lords.
Compromise.
506 खाली
Ashwandi.
Any date may be fixed.
कहीं कौन है ले?
Yes,
कौन
डाके था ना?
हाँ छोटे केस कहीं पकेगा
Only 506.
506. Joint affidavit वगैरह अच्छी?
नहीं फाइल करनी चाहिए.
फाइल करना
काली आसन तू?
Next week.
काली आसन तो next week कौन?
काली ऐसे पढ़ा हंडी रही थी.
पढ़ा हंडी तो
विसिरे पीरो.
विसिरे कर दो ना.
और दिन?
First week of February.
1st February.
First week of February.
जल्दी जल्दी केस खत्म हो बोलिए हम कोई
First week of February.
फर्स्ट फेब्रुअरी yes
I'll say how.
finish
Finish.
get cut hold of some judgments